event. It was supposed to be listed today. But
Fresh orders or after notice?
no, it's an after notice.
After notice, usually it will go as per the computerized listing system. I don't have a choice to lift it up.
But your Lordship, the IA has been filed where
Yes.
the father visitation right has not been given and he has then made his child.
So vegetation right, what is the original petition?
Your Lordship, it is transfer petition where IA has been filed.
No, transfer petition, I cannot direct vegetation right.
But an IA has been
I
filed.
hope you understand. Under which provision the main petition is filed before the trial court?
It's a Hindu marriage act and guardianship act.
Sorry?
Hindu guardianship and what that?
Guardianship and Words Act.
Yeah.
So if it is a Hindu Guardianship and Words Act, I don't have jurisdiction to pass a order for vegetation. The Lorded Trial Court would have the jurisdiction. Suppose now
But it has been
you have to listen to understand.
Yes.
You have to listen to understand because you are not following my question. So if the trial court has rejected your application for vegetation, of course. But if your trial court has rejected, the petition has to be WPC or RPFA. It cannot be TR because TRPC is section 24.
Yes, Your Lordship, I agree.
No, you or me agreeing is not important.
Yes,
Law is important. I can't pass a order in a TRPC section 24 directing vegetation right or granting contact and vegetation right to the father. So that is how when you make a submission, I went little bit fast because I have to maintain that. You must understand that if you are challenging a order refusing vegetation, then it cannot be TRPC. It is WPC or RPFA.
May I?
Sorry?
Your Lordship, may I?
Yes. You have been. I have been listening because I have to respond to you. So I have responded.
Transfer petition, the visitation right has been stayed to the transfer petition. It has been filed by the opposite party. However, due to the filing of transfer petition, it has been stayed.
Vegetation order has been stayed.
Yeah. Yes.
Are you sure?
Yes,
Filed Anand. You are from which place?
I'm from Bhubaneswar, Your Lordship.
Bhubaneswar. So you can appear in VC. You need not take your difficulty. Always appear in VC. So if do you have a copy of the order right now?
No, Your Lordship, I have the
Or you have gathered that impression?
Your Lordship.
Have you read the order
Yes.
staying vegetation and contact rights or in the
Your Lordship,
TRPC?
I read the
You have read the order? Okay. Then you should have said that.
Your Lordship.
Because you started saying it's a TRPC and the interim prayer for vegetation. So it is completely incongruous. No, please, don't be apologetic. Then I have to stop interacting. In a courtroom interaction where you are wearing, why you are then wearing coat and gown and I am also wearing coat and gown. This is nothing personal to apologize. Because whatever we are discussing, it should be legally nuanced. And I always make an effort that whatever I have told you, each point, each aspect I have made very clearly as far as law is concerned. File the baggage. Number. Likhi debe.
That PRP part. 286/2025.
Can you wait for some time?
Yes, sir.
Yes, you wait. We can take it up at.
Can it be on day after 20 or?
No.
Because the co-counsel will be also there in the.
No. First of all, I have to check whether you are saying what you are saying that vegetation order, interim order for vegetation and contact right has been stayed. So that is little bit baffling for me being a student of law. So maybe, possibly, because my orders must be baffling many people as far as law is concerned. So let us check it. Only for the listing sake, I have to.
Yes, sir.
Because I follow a procedure that no preference of any case.
Yes.
I mean, for you, of course, you can appear in VC and all that. So not to except where outstation counsel are coming, because outstation counsel, they come in the morning and say that my matter may be taken up. I have come from this place. So that is only, it is urgent and taken up at 2 p.m.
Yes.
This is only for mentioning. I am not taking it. For this week also memos are being filed.
Your Lordship,
No, I'm not asking you. I'm asking general to the bar. For this week also memos are filed or what? Because I have adopted my understanding is that let us allow all the memos, let us see how far I'm working.
লিস্ট করতে
Yes?
লিস্ট কর না
এটা ନାଇଁ ଲିଷ୍ଟ କରନ୍ତୁ ଲିଷ୍ଟ କଲେ ଲାଭ କିଛି ହବନି କାହିଁକିନା ସେ ବି ବୁଝୁଛନ୍ତି ଯେ ଅଦର ସାଇଡ୍ ନାହାନ୍ତି ନା ଫାଇଲ ଟା ଦେଖିବାକୁ ପଡିବ ଲିଷ୍ଟିଂ କଣ ସିଚୁଏସନ କଣ ସେ କହୁଛନ୍ତି ଗୋଟେ ଇଣ୍ଟରିମ୍ ଅର୍ଡର ଅଛି ତା ଭେଜିଟେସନ ରାଇଟ୍ ଷ୍ଟେ ହେଇଛି ମିଷ୍ଟର ପଟ୍ଟନାୟକ ଟିକେ ଫାଇଲ ଟା ଦେଖିବେ
why Sahoo?
So my understanding that to interdict a proceeding before trial court,
Yes.
TRPC is filed. This is a classic example. If what you are saying is correct, this is a classic example. Even by transfer, how an interim order will be stayed. Proceeding may be stayed, but you are saying the order has been stayed. State party अछंती कौन?
No,
अच्छा देखिए स्टेट के लिए भी हमें देखिए दवा कॉपी पेज वाइज करो देखो
private.
Working list page 1, 2 to 7.
Item 6, my
6 yes
praying for adjournment my lord, after vacation.
sir you are Mr. Behra I'm sorry I forgot your name
Subhranshu Jena.
Mr. S. Jena you have power here so Subhranshu Jena for the petitioner opposite party black the matter was listed on 252026 and was adjourned stop the state party na but state DNA का election थी जी but it's a party ना ऐसे अपन को नाटा order लिखा है but you are not a party अपन को copy दिया है जी नहीं opposite party blank the matter was listed on 2/5/2026 and was adjourned at the instance of the London Council for the petitioner. Today the matter being in the list is mentioned at the beginning of the day's proceeding. It is the matter being on the list for fresh admission. It is mentioned at the beginning of the day's proceeding seeking adjournment. Stop accordingly. The matter shall be listed for fresh admission in the week commencing
27.
27/2026.
Page 2, 8 to 17.
Yes.
Your Lordship, my learned senior is appearing on item
Yes.
16.
Item 16, my lords.
Yes, please.
My lords, item 16, this matter is directly covered by earlier three orders passed by your lordships. One of them, my lords, is WPC number 11923 of 2023.
Here notice to be issued.
Yes, Your Lordship.
No, notice. Yes, notice is to be issued. Interim orders, my lords. Same
Yes.
violation of item section 21 of the Lokayukt Act.
Yes,
Not
sir. And here-
hearing.
State is not appearing for the opposite party, but they would notice to go.
No. Yes, notice because they have their own panel of lawyers.
I'll pass that on.
Your lordship has already passed through. My associate will pass on the orders,
Yes, it's there.
covered order, with the necessary corrections. Grateful, my lords. Grateful.
Miss A. Pradhan.
Yes, Your Lordship.
But you should keep it a habit of reading briefs. The way that day you are placing the covenants, with the agreement, deed, everything, that you should maintain. Yes,
I will, Your Lordship.
yes. Because you left, she started placing that, but she was placing the element.
Manners.
Mr. Lenka, such a senior from amongst all of us, he will also agree. That
Manners,
she has read it. Otherwise, one cannot place a specific para and all that.
She had very assiduously assisted me in this matter.
Yes.
On the points.
There's a long way to go, but still, then these habits actually they
Manners.
put you in the right direction.
My lords. Grateful, lords. Grateful for your lordship's appreciation.
God bless you.
8 to 17 now, Kiran. ଆପଣ
item 12 not press
12 not pressed. ଆପଣଙ୍କ ନାଁ sir?
Prakash Chandra Mishra.
ଆଚ୍ଛା
Filing the not press memo
ଦିଅନ୍ତୁ।
and seeking better to file better rate application.
ଏ ଆଗରୁ ହିୟରିଂ ହେଇଥିଲା କି ସାର୍? ହିୟରିଂ
ନା,
ହେଲେ
hearing ହେଇନି।
ହିୟରିଂ ଯଦି ହେଇନି ତ ତାହେଲେ ଠିକ ଅଛି, ବଟ୍ ହିୟରିଂ ହେଲେ you must understand that the other side is appearing.
No, no,
They
no
are,
notice
state
has
appears
been-
as a kind of
no
because
notice
as
has
per
been-
High Court rules, they appear and they have to say agreed for that liberty.
no notice has been issued to other party. Press admission.
No, this cannot be liberty cannot be granted. Read the order 252026.
Hmm.
Where a matter of this court is a court of records. I can't even if I like to allow that, I cannot. 25 order ta paduntu.
No.
So, Mr. Can you just order baat karo? Acha. Achhi.
Hard Lawrence counsel for the petitioner in the REIT application alleges non-consideration of his application for renewal of a public distribution system license that was issued to him on 5th April 2004. Copy of the renewal application has been annexed to the REIT application marked as Annexure 1, which does not bear any date. The Lawrence counsel for the petitioner has adjournment to obtain instruction as to when the application was made and to which authority. The petitioner shall also have the liberty to approach the higher authority of the opposite party number 4, who is stated to have received the
The application.
The matter.
So after this, I cannot allow you to withdraw with liberty to file again. Because these questions I have to record at least. 2 and 2, 3, those are very pertinent. And this is the application of after we are considering after more than 22 years.
Accident, due to accident, it has been mentioned that in my GT application.
The accident to the application cannot be a ground. Filing of application and who received the application and when. Accident I cannot observe also. Suppose I am impressed that we are grounded accident suffered by the petitioner. But application never suffered any accident. And if you have, while traveling to submit the application, you suffered an accident, there is no possibility of submitting the application. So obviously, I cannot issue a direction to Mr. Mahanti that you consider this.
No, better application.
Better application I cannot. After part 2 and 3, after I read the brief and I pass order, so you press, because filing of a writ application is not that whenever you like, you can withdraw it. Please appreciate that.
There is no date in the application.
So I cannot allow you to manufacture another one with a date.
No,
to be blunt.
no question of
To be blunt. So then how can I do that?
no benefit.
After a record of facts, this court is not a kind of where we have a general discussion over a cup of coffee and whatever we say, let us withdraw that. That is not possible as far as legal process is concerned.
No.
Withdrawal is possible, but liberty to file another application cannot be.
RTI application रे ଦେଇଛନ୍ତି କି କେତେଟା ତାଙ୍କୁ ମିଳିଛି information ସେ RTI application amendment କରିପାରିବେ?
Sir, the problem is that RTI application, you are the protagonist. ଆପଣଙ୍କୁ RTI application କିଏ ଦବ? ଆପଣ ଯୋଉଟା apply କଲେ RTI application କଣ କହୁଛନ୍ତି? ଆପଣ ଗୋଟେ ଜଣକୁ approach କଲେ ଗୋଟେ application ଦେଲେ authority. RTI ର role କଣ ଅଛି? You are seeking a license.
Withdrawal.
Okay, liberty cannot be granted. Item 12 lekho to Mr. Prakash Chandra Mishra for the petitioner. The matter being listed for fresh admission is mentioned at the beginning of the day's proceeding by the learned counsel for the petitioner. And memo of date is filed, which states thus, the memo shall be taken on record, scanned copy be updated. On 2/5/2026, after hearing the learned counsel for the petitioner, the following order was passed. Order quote करते हैं. Italics दरकार नहीं. कहीं तो ये हमारा order है. तो quote करते हैं certain margin पे. In view of the memo filed, the petition is disposed of as withdrawn. Mr. Prem Kumar Mahanti. Bar or Mr. Mahanti?
Yes.
Additional standing counsel.
कोड
और যদি কাটিবে না ମୁଁ লিবର୍ଟି ରିଫ୍ୟୁଜ କରିବା ଅପେକ୍ଷା ଆପଣ ନ ଲେଖିବାଟା ଭଲ ବେଟର ଆଇ ଆଭଏଡେଡ ଦ୍ୟାଟ ସାଇନ୍ କରିଦିଅନ୍ତୁ ସ୍କୋର ଥ୍ରୁ କଲେ ସାଇନ୍ କରିଦେବେ ନହେଲେ ଆଉ ଗୋଟେ ମେମୋ ଦେଇଦିଅନ୍ତୁ ଗୋଟେ ସାର୍ ଗୋଟେ କାଗଜ
ଷ୍ଟାମ୍ପଟା ବାଦ ଯାଇଛି
ଷ୍ଟାମ୍ପଟା ସେ ତାଙ୍କୁ ଫେରେଇଦେବେ ସେ ରଖିଦେବେ ଆଉ ଗୋଟେ ଲେଖିଦିଅନ୍ତୁ ସେ ନାଇଁ ସେ ଶୁଣ ସେଟା ଲେଖିଲା ପରେ ଦିଟି ଯାକ ନେଇ ଆସିବେ ସେ କଣ ଲେଖିଛନ୍ତି ଦେଖିକି ଲେଖିଦେବେ ଆପଣ ଦିଟି ଯାକ ରଖିବେ ଗୋଟେ ଡେଷ୍ଟ୍ରୟ କରିଦେବେ
Page 3, 18 to 27.
Your Lordship, item 18.
Yes.
Seeking for an adjournment.
You are for the petitioner.
Yes.
What's your name?
Subhashmita Patnaik.
Ms. Subhasmita Patnaik, on behalf of the Sheikh Jafarullah for the petitioner, Mr. Other side will inform करना है orders matter था.
Your Lordship, on last occasion, you have asked to obtain an instruction from the petitioner to deposit the
That
amount.
has nothing to do with non-appearance of the other side. I cannot direct I will pass orders in absence of the other side. That cannot be the last occasion of this occasion.
But
Always be in the context of the discussion. That I have read, I have marked that why the adjournment is sought for. The issue is that if the other side comes, then what would be my answer as a court? How can I preempt them for not appearing?
Your Lordship, we have not yet obtained the instruction from the petitioner.
The matter is matter being in the list, matter having been listed for orders is mentioned on behalf of the learned counsel for the petitioner by the learned proxy counsel. C6 adjournment. The matter was earlier heard. The matter is kept pending since the last more than 10 years. Was heard at length on 8/5/2026. Noting the propositions of law as well as the facts. There is no reason the matter should be kept pending even after 10 years. However, taking a lenient view to grant further opportunity to the petitioner, the matter shall be listed for orders in the week commencing 27/2026. The copy of the order dated 8/5/2026 as well as the order as well as today's order shall be forwarded to the learned judge family court, Khurda, to be kept in the records of criminal petition number 22 of 2016. Yes.
No, please.
19 to 27.
But this order is subject to their appearing and because you are mentioning in their absence. There is no concept of orders being passed behind the other side. Yes.
Page 4, 28 to 34.
I pray for 29 item for adjournment of filing rejoinder affidavit and they have filed for vacation. Like
29
that.
state
State is there.
Sri Lanka, who is appearing in 29?
Okay. Problem is. So, it's a problem.
So the learned counsel is seeking adjournment. कौन करिए कौन? प्रभु मुझे स्मरण करो तो.
Let it be action now.
Okay. Mr. Arun Kumar Patra for the petitioner, Mr. Prabhu Prasanna Behra, additional standing counsel for the opposite party. The matter is listed for orders and is mentioned at the beginning of the day's proceeding by the learned counsel for the petitioner seeking adjournment to file rejoinder to the counter affidavit
And reply to IA.
and reply to the IA filed on behalf of the opposite parties. But I think it was listed, being mentioned by Prabhu.
Yes, later on supplied. Later on which date it was listed, thereafter he supplied the copy of the IA. So just,
So
I'll take
at least you should
instruction.
wait for him. It doesn't, like the young girl mentioning.
That's it.
You appear karantu.
Right.
I'll pass the order, but at least let us inform him
Okay.
to be fair to him.
I tried to call him. But it's not-
Yes, yes.
Item number 32, my
Just
lord.
one second. Only. The Lord AC opposes the prayer for adjournment. Stop. To grant further opportunity, the matter shall be listed for orders in the week commencing.
Odisha.
Further opportunity to the petitioner, matter shall be listed in the week commencing. ଆଉ ଟିକେ ଆଗୁଆ ଦଉନାହାନ୍ତି ସବୁ ମନା କରୁଛନ୍ତି ନା। 6-7
First of July.
6-7 ସେ 102 ହେଇଗଲାଣି 13-7 ଆଜ୍ଞା 13-7 94 just wait for it.
Interim order.
Interim order as passed earlier shall continue till the next date of hearing. Interim order টা dated কেତେ ସେଇটা
No, 16-4.
16/4/2026 yes
Page 5, 35 to
32,
40.
my lord. Item number 32.
30
On behalf of,
30 sir subilanti
item number 32, my lord.
32 yes
On behalf of Mr. Manoj Kumar Kuntia, it is read to
ଆପଣଙ୍କ ନାଁ sir
Prakash Kumar Sahu.
32 Mr. P.K. Sahoo for the petitioner Mr. Prabhu Prasanna Behra for the Prabhu Prasanna Behra additional standing counsel for the opposite party. The matter is listed for hearing under the heading for admission. Stop.
Maybe.
Comma, stop here, comma, and comma, it is mentioned by the learned counsel for the petitioner seeking adjournment. Rejoinder देना ना जानना
Sir, regented tebe.
Acha. It is mentioned by the learned counsel for the petitioner seeking adjournment to file rejoinder. Top करके भी ही पड़ेगी. IT टा capital of IT. According to the matter shall be listed for admission in the week commencing 20 କହୁଛନ୍ତି ନା 27
27.
commencing 27/7/2026
Page 5, 35 to 40.
My lord, item 36.
yes
On my mention, your lordship, this matter has come.
yeah
Wherein the execution proceeding against the son, the petitioner is the father, has been stayed. Your lordship directed me to instruct Mr. Mahapatra appearing for the petitioner. I have informed, we have discussed. Your lordship may call it after vacation. On 3/9/2024, while granting stay, this honorable court has directed it will come in fresh admission.
order से आसु
हाँ।
से आज आसीबे
ନାଇଁ ସେ ମତେ କହିଲେ ଯେ ଆମେ ମୁଁ କହିକି କଥା ହେଇକି କହିଲି ସେ
ତାହେଲେ order से ଆଣିବା ମାନେ आपसे कुछ ना आसीबेनी बोली
ନାଇଁ,
ବହୁତ से ଆସିଲେ ଆପଣ ପ୍ରେଜେନ୍ସ ରେ କିଛି ତାଙ୍କୁ ପଚରା ହେଇଥା କହା ହେଇଥା ପଇସା
Your
ଦିଅନ୍ତୁ
lordship may bring it in order.
in one matter in Sambalpur have succeeded
ଆଜ୍ଞା।
please course Mr.
ମୁଁ କଥାବାର୍ତ୍ତା ହେଇଯାଇଛି ସେ ମତେ କହିଲେ ଆପଣ ଟାଇମ ନେଇକି ମୋ ଏଣ୍ଟ୍ରି ମର୍ଡର ଟା କଣ୍ଟିନ୍ୟୁ କରିଦେବେ
ସେ ଚେଷ୍ଟା କରନ୍ତୁ ଆପଣ କିଛି ପଇସା ଡିପୋଜିଟ କରିବା ପାଇଁ ଦ୍ୟାଟ ମଦର ଆନ୍ସର
ସିଏ ଡିପୋଜିଟ କରିବେ
ହଁ ବୁଝିଲି
ଆଜ୍ଞା
ଆପଣ ମାନେ ସିଏ
ଆଜ୍ଞା ସେ ମତେ
I got it so that is how I was asking that he will not whether he
ସେ
will come
ମତେ
or-
ସେ ମତେ କହିଲେ ଯେ ଆପଣ ଟାଇମ ଟା ଆଫ୍ଟର ଭେକେସନ ରଖି ମୋ ଏଣ୍ଟ୍ରି ମର୍ଡର ଟା କଣ୍ଟିନ୍ୟୁ କରିଦେବେ ଟିକେ କହିକି so that is his
okay
request.
anyone present on his behalf
ନାଇଁ,
କିଏ ଅଛନ୍ତି
ନଥିବେ କେହି
Mr. Rivina.
I have
No, I understand.
my
I would have recorded, he marked his presence. That
yes
36 Lekontu. The matter is listed, Mr. Udananda Mahapatra for the petitioner, Mr. Umacharan, Mr. A. Misra for the opposite party. The matter is listed for hearing under the heading for admission, single court hearing, para. It is submitted by the learned counsel for the opposite party that it has been listed, being mentioned by the opposite party. Priyanshu is the father,
Priyanshu is the son. Dr. Kumar Tripathi is the father.
by the learned counsel for the matter is mentioned and it is submitted. Matter is mentioned by the learned counsel for the opposite party and it is submitted that though the matter is listed being mentioned by the opposite party, the learned counsel for the petitioner has difficulty to appear on personal grounds and the matter may be listed for orders. Stop. Accordingly, the matter shall be listed for orders in the week commencing 13/7/2026. The interim order dated
3/9/2024.
3/9/2024 shall continue till the next date of hearing.
Yes, it would be kind enough to fix a date, my lord, 14th July.
You should be kind enough to allow the matter to be listed. You must understand the niceties or nuances. If you give it a date and it is no, by chance they can't list it, it goes out of list because they can't go beyond a judicial order. But if it is in the week commencing, then they are able to adjust it. And that has worked actually.
Lordship, very sorry to say, item 22.
Yes.
That I am the petitioner. The opposite party has requested for a time. There is no stay. It's a but announcement.
Mr. Swaroop,
He requested for a time. Probably he is unable to be connected in the VC. Lordship, 4th July, the execution is pending in the lower court. Any date after vacation on 22nd, 23rd of June.
22 interim order achi.
Na, that announcement kindu ଏଇଥିପାଇଁ ଆମର execution ଟା lower court ରେ saying that it is pending here, but execution is being unable to proceed. So 22nd, 23rd June.
The order se bhi achi.
Order se let it come to vacation. There is no interim order.
Mr. A. Misra for the 22nd, Mr. A. Misra for the petitioner, Som Swaroop for the opposite party. The matter is listed for orders and is mentioned by the learned on behalf of the learned counsel for the opposite party seeking adjournment. Stop. Accordingly, the matter shall be listed for orders. Mentioned at the beginning of the day's proceeding. Mentioned at the beginning of the day's proceeding by the learned counsel for the opposite party seeking adjournment. Accordingly, the matter shall be listed for orders in the week commencing 29/6/2026.
Item 40.
40. Yes.
Item 40, I'm going on behalf of Mr. P.K. Chan, saying for an adjournment.
Mr. Mohanty appears in VC, so maybe he will be coming from Bhubaneswar. Have you informed him?
Informed him already.
Okay. After notice.
Yes, sir.
Simply date कर दियो. Order कहीं.
We continue 20/7.
20/7.
Okay.
(41 to 47). 42.
Yes. If time permit, let's say, can take on last item.
The last item I am not taking up. Let us see how far I am able to go. Let us see. Then 48 to 52, 53 rather. Okay. Call the list one.
Item 1.
Pardon for the mention, Your Lordship. Item number 31 on behalf of Mr. Arvinda Mohanty. The IA has been served. Kindly allow us some time to take instruction.
So have you informed the other side? It's
Yes, Your Lordship. We have
so
communicated.
it will be adjourned to a date.
Yes, Your Lordship. We have communicated.
For admission. 31 टा उड़े posting करो तो.
We continue 20/7.
20/7 week रहे.
Obliged.
Yes.
Item 1.
May it please, Your Lordship.
Yes.
Your Lordship, the matter is regarding grant of benefit of UGC scale of pay. In a similar matter, Your Lordship has passed this order. Last week also,
Yes.
there was a similar matter.
But this is kept pending for 2006. That confusion is not there. That Supreme Court has directed.
Your Lordship.
Supreme Court has directed in those 65 cases.
Yes, Your Lordship.
Have you gone through that order?
Yes, Your Lordship.
Okay. So can you just carry out the necessary
Stop.
corrections?
Yes, Your Lordship. I
Make some
carry on this.
necessary changes and show it to Mr. Lenka.
No, other day, last on 15th,
Yes.
item 2, that is different to item 1, then 15th. So your lordship has, that order has not been yet been
No,
uploaded.
that was corrected only yesterday. I had some last questions.
But
so-
this matter is similar to item 2,
It is covered by.
not item 1.
No, basically what Mr. Lenka is saying, that there is in one case, there is
Mr. Purohit was doing.
there is a letter by the director asking the person to give the records. That is after the decision of the Supreme Court. But in some cases, like what Mr. Bahidar argued is that, I'm sorry, Mr. Purohit argued is that this has been remanded by the Supreme Court. In fact, he was insistent on that. But somehow I could not persuade myself. The market is a 2013 matter. Still, the SLP is filed much later in maybe 2025.
Yes.
Something in 2023 or even much after this. So there is a little bit difference. So I'll pass this order.
No, your lordship may pass that item 2. Mr. Shekhar was,
Give the number of people recognition, Your Lordship. It was listed on
Yes, yes.
15.
Mr. Shekhar was doing.
Yes.
I'll
This is
write
the same order. No, I have edited that. That submission that it has been directed by the FX court. It was
para 3.
para 7. Look at para 7.
Yes, sir.
Yes, sir.
Though it is suggested by the learned counsel for the petitioner that case of the petitioner has also been remanded and is covered by the direction of the apex court in order dated 29/1/26. Apparently, the present writ application was present writ petition was filed by the petitioner in 2013, which is still pending consideration and disposal before this court. So, because this was to, take note of Mr. Purohit's submission, because he was somehow convinced that it is remanded. But if it is remanded, then how the writ petition is pending here?
Pending here, yes.
Supreme Court has to remand it.
Yes, sir.
So I have edited it. So that I have. The similar item number 30.
Item 2.
Item 2 on 15/5/2026.
For marginal equivalent. Item 2.
14929 by 2013.
14929
by 2013.
30.
13. এটা ফেরে দিন।
Both the cases are retouched.
Okay.
Good.
Also, those land acquisition matters, because that batch of land acquisition within the railway company, the state is also a party. Those judgments will be though it was pronounced in court, but they were edited yesterday. So if you are looking for them, so it takes some time. Yesterday was a very long day actually. Yes. So both matters are disposed of.
Yes, sir.
Okay. Same 1-3 on sorry. Mr. Lenka. Today, you will be appearing on behalf of who is the counsel now retained in your, who is still continuing? Ms. Charvi on behalf of Ms. Charvi on behalf of petitioner, because all of them are no more.
Yes, sir.
I am for OP 1 and 2.
For the petitioner, line add for you, it is submitted by the learned counsel for the petitioner that she has been entrusted the brief by his senior and he represents the petitioner. Your line add for you. The DN Lekka, additional government advocate, additional government advocate for the
1 and 2.
1 and 2.
Both the cases.
Both. OP3 notice ହେଇଥିଲା? OP3 blank ଛାଡି ଦିଅନ୍ତୁ. OP3 blank. Because whether notice was issued, whether it was sufficient, those things. Any idea, Ms. Charvi, have you read
Yeah,
State versus Alok Kumar Misra? What happened there? SLP, because if you look at this order, 4969.
Your Lordship, I'm not aware of the.
But you are happy to have this order.
Yes, Your Lordship.
Consideration by the is Alok Kumar Mishra is different. And because Alok Mishra follows Sahoo. So that is not appearing in those matters, but anyway, these are. Okay. Second is same order. Party. Party is same Miss Charvi. उससे तो बीबी राउत रे इस्तास इस जना की ना पीके सौ तो additional standing counsel दिलीप महापात्र तो तो say line का रहो Charvi on behalf of the petition. Mr. Lenka 1 and 2.
Item 2,
Yes, please.
May I see? Petitioner challenges the order dated 29/7/2000.
Mr. N.K. Mahanti. Mr. B.K. Mahanti for the petitioner. Opposite party black. Yes, Mr. Mahanti.
Challenging the order dated 29/7/2022.
Yes.
Passed by the Lawrence Hamil Judge Nabarangpur and directed to pay this amount 10,000 to the opposite party wife, Your Lordships. And from since that period, I am each and every month, I am paying the rupees 10,000 regularly. And
so you have the order. Can you just look at the paperless? Use that. Yes, sir. Again, we have to go virtual because of the situation, energy crisis.
Yes.
So you have to use this. Please kindly look at order dated Padarachari. Because though it is of 2022, it has been recently listed before this bench.
Yes.
So kindly look at order dated. Take upon साहाଯ୍य करो. ठीक काढ़ी परिवे जेटा this issue it becomes easier also. Bookmark टा click कले है ना 30 दिन बाहर ना पढ़ीवे. ठीक है, Mr. Mahanti.
Yes.
कि अंकु Mr. Prabhu को inform करो तो Mr. Patra is waiting. Because now I have kept him waiting. Though you said can be, but ଆପଣ ତାଙ୍କୁ ପଠଉନାହାନ୍ତି ଫୋନ କରିଦେଲା ହବ. He can appear in VC, no difficulty. We have to go back again, though now there is no social distancing, but defect remove ହେଇଗଲା.
Yes.
अच्छा.
Only for 3 rupees was.
ତାହେଲେ ସେ defect removal ପାଇଁ ବାରମ୍ବାର list ହଉଥିଲା.
Already removed, Your Lordships.
ବର୍ତ୍ତମାନ କେସ୍ ର status କଣ ଜାଣିଛନ୍ତି କି? What is the status? Are you talking to your client?
Yes, Your Lordships.
Yes. So what is the status?
Your Lordship, status is the wife is residing in your parents' house, and one son and one daughter. Daughter has already been married, and son is also residing at New Delhi and working as a Air Force employee. And father is now retired from his service 28 to 2018 and getting up rupees pension, Your Lordship, 26,551. And then he also purchased a flat, Bhubaneswar, and she approached her wife to stay along with her, but he refused to stay along with the petitioner. And he is ready to
ସବୁ କଥା ବୁଝିଲେ କିନ୍ତୁ ଡିକ୍ରି କଥା କିଛି ପଚାରିଲେନି. ସେ ଯୋଉ ଡିକ୍ରିଟା ହେଲା ତାକୁ ଫୋପାଡ଼ି ଦେଲେ ନା ନାଇଁ କମ୍ପ୍ଲାଏ କଲେ?
comply with
ସେଟା affidavit ଦିଅନ୍ତୁ. It is submitted appearance tax it is submitted by the learned counsel. लिखिए pursuant to the order dated 5/5/2026. The learned counsel for the petitioner is present and he submits that he has received instructions from the petitioner. It is submitted that the children of the petitioner and the opposite party, the children born from the wedlock between the petitioner and the opposite party have grown up. The daughter has got married. The son is now working. The son has joined Air Force.
Air Force.
The son has joined Indian Air Force and works there. Being posted at Delhi.
New Delhi.
It's further submitted that as per the instructions received, the petitioner goes on paying the amount of maintenance directed by the Lord Judge Family Court, Nabarangpur, by judgment dated on 30/7/2022 in CR.P. number 04 of 2020. Thus, in view of the said submissions, it is directed the petitioner shall file affidavit indicating the details of payments made pursuant to the judgment dated on 30/7/2022. The affidavit should be brief and indicate the date of payment, mode of payment, and amount paid. Stop. Keep affidavit debe.
Within weeks. Within a week.
Within a week. तो week तो सॉरी गला. तागुर ही परिवन. Yes.
तो कोई के नबरंगपुर एठी रहउछंदी बेले बेले नबरंगपुर पळै जाउछ. As an old man. The affidavit, as prayed for, the affidavit shall be filed within 10 working days. The matter shall be listed for fresh admission in the week commencing. 6-7 ଆପଣ ଯୋଉଟାକ adjourn କରୁନାହାନ୍ତି କି ଟିକେ ସେଇ ଅର୍ଡର ରଖିବେ ଆଗ ଫ୍ରେଶ ରଖିବେ ତାପରେ ଭର୍ତ୍ତି କରିଦେଲେ ପୁରା 6-7 ରେ 102ଟା କରିଦେଲେ 29-6 ରେ 100ଟା ମ୍ୟାଟର କରିଦେଲେଣି 13-7 ରେ ବି ପାଖାପାଖି 100 ପହଞ୍ଚିଗଲା the week commencing 6-7-2024 judgment your lordship page 4 and findings रे अछि total clearly mentioned finding para page 4 रे the opposite party is ready to accept the petition
acceptance
he is refused each and every
ସେଇଟା ଶୁଣନ୍ତୁ ସେଇଟା ଆପଣଙ୍କର ଏଟା debate competition ରେ ହୁଏନି ବୁଝିପାରିଲେ legal process is not a debate competition it's a written plaints as well as evidence ଆପଣ ଯଦି evidence of plaint ଅଛି
वो evidence ମୁଁ chief ରେ କହିବି
ଦେଖିବେ ସେଇଟା ତାକୁ ସେଇଟା ଆପଣଙ୍କର if you read because it's a very old act 1955 now you cannot compel someone to leave and you cannot take the plea if the wife is staying separately or husband is staying separately because of any particular reason so that is a different thing ଆପଣ ଯୋଉଟା ଆର୍ଗ୍ୟୁ କରିବାକୁ ଚାହୁଁଛନ୍ତି ଯେହେତୁ ସାଙ୍ଗରେ ନହନ୍ତି ମତେ ଦବାକୁ ପଡିବନି ତ ସେଇଟା ଆପଣଙ୍କର କଣ ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟରେ କଣ ଷ୍ଟାଣ୍ଡ ନେଇଥିଲେ ସିଏ କଣ ତାଙ୍କୁ ଏକ୍ସାମିନ କଣ କଲେ voluntary desertion can be a reason for not paying but you have to plead and prove there and how the court has dealt with it
if mediation be your lordship mediation
पैसा रे मु तो देई परिबिनी आपण देई परिबे कि पैसा कोंतु देबे ताले मु मेडिसिन पठेबी पैसा देबार मेडिसिन कोन हो मिस्टर जेना आर्ग्यूड ओटीएस बैंक रे जो ओटीएस होनी से ही आर्ग्यूड ओटीएस that is very innovative but how the maintenance for the act is to prevent vagrancy and destitution mediation कोन हो
I am ready to
माने किए कोठी पैसा मागिबे
my wife but if he
आपन को readiness to take back is not a defense to not to pay maintenance please appreciate
maintenance is regular paying
such they say affidavit देबे so that at least ताको notice issue करियो क्यों तो आपन affidavit आजि फाइल करिवार थिला I don't know माने you should have filed because sufficiently आपन गडा continuously list होची March 26 ru June May masare continuous list hochi and by now you know the orders have passed should have filed that affidavit yes next please
Item 3.
Ms. Mahapatra Ms. Manas Mahapatra for the petition yes please
The order of family court is under challenge before the Hon'Ble court, my lord.
yes
Case of the opposite party is that case of the opposite party before the family court that she had after the death of the first wife of the present petitioner she had married to him in a temple and she is entitled to maintenance. The Honorable Court below allowed 5,000 from 2014. till yet what happened, I don't know, execution was pending. I don't know what happened to the court below, but what is the stage of, it's because.
So old matter you should have instruction?
Yes, no instruction, it's because I had sent 2 letters to the present petitioner, and there is no communication with the present petitioner.
Registered post have you sent?
No, the registry post I had.
Now it is now speed post, no more registered post,
No,
speed post with
earlier, no.
station you have sent.
Yes. On the,
So you want to plead no instruction or you want to adjournment? You want adjournment?
if it is urgent after vacation, I will send, once again, I will send the speedy post to
Once
the
you
same
send,
person.
that is enough.
Yeah, to the same person.
You cannot run after somebody who is
Yes.
not interested. Okay. Parents लिख लेना. Anasi Mahapatra petitioner. The petitioner husband in the marriage is before this court. That by filing the application, he seeks revision of the judgment dated 31/10/22 passed by the Lord Judge Family Court Balasore in CR.P. number 73 of 2014. The said application was filed by the wife in the marriage and 2 children born from the wedlock. Seeking monthly consolidated maintenance at the rate of rupees 10,000 from husband-father. Stop. The application was favored. The application was favored, however. Directing payment of monthly maintenance at the rate of rupees 5,000. From the date of application, that is 7/5/2014. The learned counsel for the petitioner is apprised of the judgment rendered by the Honorable Apex Court. That is Tamima Faruqi versus Sahib Khan. That deals with scope of interference of this court in exercising power of revision of the judgments passed by the Learned Family Court under section 125 of CRPC. The Learned Counsel is further apprised of the judgment passed in para 20 para 20. The Learned Counsel is also apprised of the judgment rendered by the Honorable Apex Court in Rajneesh versus Sneha, wherein it has been directed and held that the grant of monthly maintenance is akin to a money decree. And for entertaining challenge to same, the petitioner has to secure the amount. So as per the Learned Counsel upon instruction submits that the petitioner has not paid any amount towards maintenance as directed. Though stop. The total accumulated defaulted amount comes to from 7/5/2014 to 7/5/2026. 144 ମାସ ଗୁଣନ 5 ହେଲା 5,000. Stop. The petitioner shall file affidavit indicating how he will secure the amount defaulted till date for sustaining the challenge. It is further submitted by the Learned Counsel for the petitioner that she has been making effort by sending letter to the petitioner by speed post with registration and proof of delivery. The petitioner remains incommunicado. Stop. To grant further opportunity to the petitioner, the matter shall be listed in the week commencing We state for fresh admission in the week commencing
13/7.
13/7/2026.
Item 4,
Mr. Dilip Kumar Sahu for the petitioner. Yes, Mr. Sahu,
My lord, this.
you are for the
I am
other state.
appearing for the opposite party.
You are Mr.
Agnihotra
Sahu.
Sahu, my lord.
Mr. DK Sahu, Dilip Kumar Sahu for the petitioner. Mr. Agnihotra Sahu for the opposite party. So this is a fresh matter.
Yes,
My
Lord.
lord, yes, matter. I have soft copy to the opposite party, my lord.
No,
Copy दिया
nahi,
है।
diya hi nahi.
अरे हेला ठीक अछि आ गोटे देबे let us not आपण एते जो what is the matter, sir? Mr.
My lord,
Sahu?
this is a petition
Take
challenging
your
the
seat.
rejection
That's
order of the.
Copy has not been sub. This is the.
Correct. No difficulty.
My lord.
He must be having the receipt or something, otherwise he will not say.
If he has a receipt, he can show it. I will not object. my lord.
No. Please wait, sir. Please wait.
Yes, sir. Lord.
I am not presuming that you are having a copy, or he is not presuming also. Kuntu, ठीक अछि.
My lord, petitioner challenging the order dated 3/7/24 passed by Lawrence Judge Family Court Bargad rejecting the plaint under section order 7 rule 11 of Civil Procedure Code in met case number 767 of 2021. My lord, order dated before this, my lord, the opposite party had.
Who was the petitioner before the trial court?
My lord, petitioner opposite party, Dr. Hrusikesh Parikh, my lord.
So who filed order 7 rule 11?
My lord, petitioner, at that time respondent filed.
Okay. Before the trial court, the respondent filed. So order 7 rule 11 has been rejected.
Rejected.
Okay.
My lord, why this petitioner filed, my lord? Earlier the opposite party.
Order, kindly just go through order 7 rule 11. जोटा आपण इन्वोक करथिले से पिटिशन टा काय
Petition, my lord, under annexure
2
my lord.
yes पारावांटा पढନ୍ତୁ पेज 14.
The petitioner had filed met case number 31 of 2014 in the Civil Judge Senior Division Bargad, disclosing the cause of action arose on dated 2/6/2013 when the deponent left his company. The very suit was dismissed on merit against the petitioner on 8/1/2016, and there is no cause of action, and the same was confirmed in Matta number 2 of 2016, dismissing the appeal filed by the petitioner appellant in the Court of District Judge Bargad on dated 17/2/2021, and on the same cause of action, Matta 30 of 2021, filed by the petitioner appellant in the Honorable High Court of Orissa, Cuttack, was dismissed as withdrawn on 1/9/2020.
So present match case टा कोन दिन फाइल हैला को डेट रे
Present met case was filed thereafter, my lord. Present met under annexure 1, same cause of action, my lord.
जे सेटा आपण को पार्ट रे देखुछन सेम कॉज ऑफ एक्शन केमति देखेबे से
Dated ta, my lord.
no आपण have you examined the law on this same cause of action in Hindu Marriage Act section 13 can a plea be taken? Have you examined the law on this?
My lord, because my lord, same cause of action. This is bar by
Question sir जोटा question पचारे छडे तो रेजुडिकेट आपण सर आपण छडे तो order 7 rule 11 देखेबे
same 13 रे से.
So whether 13 res judicata can be involved, have you examined the law on this?
Yes,
Co decision.
my lord, the order dated.
Order dated केमति हो citation को decision Supreme Court रे आपण पढिले कि मुला रे पढिले कि माइनस हिंदू लॉ रे पढिले?
My lord, there are some citation I have.
पढिचंती कि experiment करंतुनी
मु आनी भी सेटा citation ता आनी.
then the problem is that you are arguing a impossible argument. आपणकर matrimonial cause रे
My lord,
have you ever thought about it? Your learned counsel who is instructing you, has he ever thought about it that matrimonial cause why res judicata is not pleaded?
My Lord and Aunt is here. You may explain if your Lord.
Has he read, sir? Explaining is not important. I am not asking facts. He is welcome.
He has filed a.
But does he understand what he is arguing?
My Lord.
But does he understand what he is arguing? What is the difference between a matrimonial cause and a like a declaratory relief or a money suit or a injunction suit,
No, this is
partition suit?
this is
This is a matrimonial cause.
and that
So 13, what is the ground in the first case?
first case, my Lord, they have taken ground against these petitioners.
What is the ground against? Straight away come to the ground. Kona ground? 13 re kona ground nahi paribe. Yes. In 13, what grounds you can take? You are the conducting counsel. What grounds in 13?
The petitioner has taken ground.
Kona ground is general. It's just like a student of law I am asking. What grounds you can take in 13 application by filing against husband or wife? What grounds are available in 13?
Cruelty, desertion.
Yes. Cruelty, desertion. So cruelty, desertion, whether res judicata will be available for cruelty, desertion. Why the law is not devolved?
Her met case is treated as a suit.
Ordinary, that's the problem.
And issue has been framed.
Which decision?
Is there any cause of action? Issue
Sir, you are forgetting. You are arguing in the High Court. You must read. Mad case is treated as a suit. That is you are not discovering it. What is the concept of cruelty and desertion? You must understand. After dismissal of a mad case, can the wife or husband cannot be said that to have committed cruelty or desertion? That is how the law has not evolved. Have you examined res judicata?
Yes.
So have you ever seen that mad case res judicata? So ସେଥିପାଇଁ ଆପଣ ଯୋଉ ପ୍ରଶ୍ନର ଉତ୍ତର ଦେଲେ ନାହିଁ ଏବେ I asked you a question ଯେ ଆପଣ ଯୋଉଟା ନୂଆ କେସ୍ ରେ 21 ରେ ପ୍ଲି କଣଟାକୁ ଯୋଉଟା କହୁଛନ୍ତି ଯେ it is a order 7 rule 11 because already a suit has been dismissed. ଆପଣ ସେଟା କୋଉ ସୁଟ୍ ରେ ନିଅନ୍ତି res judicata?
Any suit?
13 ରେ କାଇଁ ହଉନି ତାହେଲେ 13 ରେ କାଇଁ ହଉନି?
13 ହବ sir.
କେମିତି ହବ?
ଯୋଉ ଇସ୍ୟୁ ଗୁଡାକ ଡିସାଇଡ୍ ହେଇସାରିଛି ସେଇ ସବୁ ଫର୍ଦର କାହିଁକି ଡିସାଇଡ୍?
ଆରେ ସେଟା ଆପଣ ତ ଓଡିଆରେ କହୁଛନ୍ତି ମୁଁ କଣ ଓଡିଆ କହୁନି ଆପଣଙ୍କୁ? Desertion once decided means for all lifetime it is desertion is disproved. Then cruelty. Husband जो दिन सुट रे जितिले से दिन आसी वाइफ को बाड़ेले कौन होता है? वाइफ जो दिन डिसमिस हो गला घर छड़ी पळेले तापर कौन अपन तो बढ़िया आर्गुमेंट करछन. Can a court sitting can a family court decide a matter of future action?
Future action.
काली desertion हवा. Can I decide it today? मु तो family court हेई परिबेनी because I don't have jurisdiction. So that is the question to you. So you must have studied and prepared that way. And if you look at your order 7 rule 11 petition, this is as vague as vague could be. पढ़िले आउतरे जोटा पढ़िले आपण पढे पे किछि लेखिना nothing. Paravan पढନ୍ତୁ 6.
The petitioner has filed.
बट आपणकर कहया गला जे आपणकर जेतेबेले धरनो गोटे बनी सुट फाइल कले सेटा काहे res judicata आइगला? Why res judicata? The reason being the claim, inter se claim has been decided. But when you are taking that plea, that desertion, voluntary desertion, of course, not in आपण बाडेले तापर कहबे जे मु बाडेली स्त्री पळेला but she has deserted.
There is chance of restitution also.
Restitution chance छाडो. सेटा आउट जिंस सेटा आपण that you have made a very good point. So what will after restitution of conjugal rights suppose file ହେଲା तापर जदि desertion ହେଲା कोन हो? So that is how this branch has not developed. A determination of a 13(1) application can never be a res judicata unless most likely that is not the case. That is you have not pleaded anything. Upon plead can call any seat. ତାର ପଢିବ ପାରା 1 ପଢନ୍ତୁ କଣ ଲେଖିଲେ
The petitioner had filed met case.
ସାର୍ ବି ପଢନ୍ତୁ ଆପଣ ତ ପଢି ସାରିଲେଣି ଥରେ ମୁଁ ତ 3-4 ଥର ପଢିଦେଲିଣି ତ ମୁଁ ଆଜ୍ଞା ଏଠି ବସିନି ଆପଣ କେସ୍ ରିଜେକ୍ଟ କରିବା ପାଇଁ I am searching to find out a legal point so that I can entertain you when the court is interacting not with the purpose of rejecting. If I would have rejected, then I would have simply said rejected. No difficult. I can give good results. आपण पढ़िले कौन लिखिले सितरे?
What process?
हाँ पढ़ू नांदी. आपण तो गोटिए पारा करछन टोटल आउ. पारा 2 रे तो ठीक अछि. पारा 1 and 2 but पारा 1 आपण को नरेशन. कोर्ट रे म्यूटेड पढ़िले आपण कोन पढ़छन मु केन जानि.
Filed met case number 31 of 2014 in the court of civil judge SD Bargar. Disclosing the cause of action arose on dated 3/6/2013. When they
भूल स्पेलिंग मिस्टेक है जी जेड़ा रेस्पोंडेंट हो रेस्पोंडेंट है ये
spelling mistake. Left the
हमर
company.
सो स्पेलिंग मिस्टेक चली जाउची हो रेस्पोंडेंट ला रेस्पोंडेंट लेफ्ट हिज कंपनी आउ किछि लिखिले नि सर
The case was dismissed on merit against the petitioner on dated 8/1/2013.
एटा आपण भिसी रे आर्ग्यू करथिले ना एटा आपण भिसी रे आर्ग्यू करथिले बिफोर दिस कोर्ट I think same cause was no please don't hesitate don't be afraid or nobody is against you at least I am not against you otherwise I would not have spent my time like this कोठी आपण कर कोनटा रेसिडुडिकाटा केमति लिखिले ता दिरे किछि तो नाही
This is not a petition for that the suit is barred by principle of residuicata. It is a petition order 7 rule 11.
करेक्ट पढ़ो तो सर वेरी गुड पढ़ो सर तो बिल्कुल पढ़ो त लिखिले काहेंगी जति रेसिडुडिकाटा लिखु नांती आपण जोटा लिखिले द वेरी सूट वाज डिसमिस्ड on merit against the petitioner and that there is no cause of action the same has been confirmed छोटा काहे लिखतले ताले
all document also.
Lower court decided that the civil court, the single division decided that there is no cause of action so far as the liaison is concerned. Liaison of wife is concerned.
डिजेशन पूछो
Liaison of wife is
डिजेशन तो डिजेशन कहले ठीक अछि बट सेटा आपण आपण बर्तन सेटा लिखि देले के पारा 1 रे कोन लिखछोनी आपण ताले पारा 1 का आपण निजे लिखिछोनी पढुछोनी सेटा आपण कोजन सेटा नो बोली आपण निजे लिखि फाइल करछोनी त ना आउ की फाइल कर देला
and the same will be confirmed in matter number 2 of the year Sulla dismissing the appeal filed by the petitioner the appellant in the court of District Judge Bargar on 17/2/2021 and on the same cause of action the matter
आपण
number
जो सेम लिखछोनी इंग्लिश रे सेम अर्थ कोन सेम कॉज ऑफ एक्शन टा मैट्रिमोनियल सूट रे हबो बोली डिजेशन ऑफ क्रुएलिटी टा से थरे ग्रांट हे गले सेटा आ हबोनी बोली डिजेशन ऑफ क्रुएलिटी हबोनी सेटा आपण सित में पचली व्हाट विल हैपन टुमारो हाउ द कोर्ट विल डिसाइड टुडे
my submission is that
आपण आपणकर कोन हेता ना सेटा आपण ए जिंसोडा को कोन करथांते इंस्टेड ऑफ फाइलिंग ऑर्डर 7 रूल 11 what you should have done
now my submission is that there is no cause of action to file the present suit I mean
सेटा कोठी पाइले ऑर्डर 7 रूल 11 रे डिजेशन हेले नो कॉज ऑफ एक्शन कोठ सेटा अछि
file lower court judgment
ऑर्डर 7 रूल 11 ता पढिबे ना आगो
order 7 rule 11 lower court
आगो आगो ऑर्डर 7 रूल 11 आगो पढंतु बही अन्नांदी ताम सिपिछि दियन कोडा कोडा आपनकर कोउटरे आपण क्लेम करछो
Order 7 rule 11 rejects
आपण कोउट रिजेक्ट सेटा तो A रे रिजेक्ट कर ठीक अछि when it does not disclose a cause of action पढ़िले प्लेन टा कोठी डिस्क्लोज करूँ 8 is toughest 11A is toughest 11A ର प्लेन टा पढ़िले
My solution is that
अरे सबमिट करंतु नै गा डेवलप हैबिट ऑफ रीडिंग आपण जदि न पढिबे
the disclosed cause of action is
सेटा
not
पढंतु हां एग्जैक्ट सेटा पढिबे ना आपण भाषण देबे की आपण प्लेन रे जोटा डिस्क्लोज करूनी सेटा पढिबे ना नहीं ना अंदाज करी हो सेटा को
disclosed
हां
disclosed cause of action is
पढो सेटा
2nd June 2013.
अरे सेमती कोन पढिया कहले आपण एबर स्ट्रगलिंग पढंतु को पार्टटा आपण डिस्क्लोज करूनी कॉज रे व्हाट क्लॉज व्हाट इज दैट नॉट बीन यस
Now, I am saying the disclosed
आपण
cause of action is not a cause of action.
आपण प्रॉब्लम होची जे यू आर नॉट रीडिंग एंड सेइंग आपण सेटा आगो पढिबे बिकॉज 11A is very specific where it upon you have to read that it what do you mean by it where the plaint does not disclose a cause of action so read the plaint how do you find that there is no cause of action
In the plaint, a cause of action has been disclosed.
पढ़ू ना भाषण कहीं दौरान लीव द हैबिट ऑफ स्पीच एक्सटेम्पोर स्पीच इज अ वेरी बैड हैबिट इन लीगल मैटर्स
After marriage, in course of time,
टू पैराग्राफ पढ़ुछन बर्तन पढ़िले विदाउट रेफरिंग टू पैराग्राफ पढ़ कहिबे स्टेट टाइम मु तो धर की बसछि सेतेबेलु पढ़ो
after marriage, it came to in course of time, it came to notice of the petitioner that the respondent had misrepresented about the educational qualification and that she led relation with several persons before marriage. It further came to the petitioner's notice that she continued to maintain such illicit relationship even after marriage. When such matter was asked by the respondent, dispute started between them. In course of time, the relationship deteriorated day to day. Thereafter, in spite of all efforts made by the family, relatives, family members and relatives, and friends of the parties, the dispute could not be resolved. Ultimately, on
बहुत समय नोचन पढ़े पे नहीं छाड़ो छोड़ो याडे ना तू पारा 4 रे आपण से कहले misrepresented about her educational qualification the earlier suit was regarding this misrepresentation issue frame ହେଇଛି ठीक ଅଛି relations with several persons before marriage ସେଟା ବି decide ହେଇଛି ଦେଖିବେ ଆପଣ ଦେଖିବାକୁ ପଡିବ that she continues to maintain illicit relationship with even after marriage से आरो सूट टा देखंत आरो प्लेन टा पारा नो प्लेन सूट रो जो सूट रे आपण कहउछनी सब गुडा डिसाइड हेछि से प्लेन देखेबे मैट केस 31 बा मैट केस 31 ऑफ 2014
पारा 3 of the
अरे कोठू पेज को पारा 3 आपण पॉकेट रु बाहर करी कले होबो की
my lord otherwise my lord we have
otherwise you are not even bothered
for this honorable court
so
that
relying on something you are not bothered to place it on record
no my lord
काई सेटा where is that
एटा हमें फाइल न कले आपण को भी बुझै पारिब नै
काई फाइल करचंती आपण को जोटा आपण जदी केस को गोटे क्रिएट करिवे विदाउट बेसिस ऑफ विदाउट फाइलिंग एनी डॉक्यूमेंट What is
suit
this going on, sir?
copy total darkar हमको suit copy
कहीं prepare कौतले? Why you have developed this habit of not looking at the pleading, not looking at the brief, and filing everything in High Court without basis? ଆପଣ ଯୋଉଟା ଉଲ୍ଟଉଛନ୍ତି ସେଟା ମତେ କହିବେ ନା ନାଇଁ ମୁଁ ଦେଖିବି ନା ଆପଣ ଦେଖିବେ?
ସେଟା
Not only that, you have to
file କରିବୁ
file କରିବେ ତାଙ୍କୁ ବି ଦେବେ.
ଆଜ୍ଞା
What is this going on, sir?
ଆର copy ଦେଇଦେବୁ ଏଇ ତିନିଟା set
Now come to the
so that we can explain better my lord.
Explain କିଛି better କରିବାର ନାହିଁ. You are on a barking upon a wrong tree. You are see the English proverb. ଆପଣ ଦେଖନ୍ତୁ, but now come to the judgment. For the you should have examined this before filing the case. Then come to page 17. ସେଗୁଡ଼ା ଯୋଉଟା ଆପଣ ପାଖରେ ଅଛି ତାକୁ ଉଲ୍ଟେଇ ଲାଭ ନାହିଁ ସାର୍, ଆମେ ତ ଦେଖିପାରିବାନି ନା. Page 17 of the brief ଆସନ୍ତୁ.
Order dated 3/7/2010.
No.
The order is arising out of petition dated 2/2/24 moved by the respondent. The petitioner has already filed objection, already had both sides. The respondent has submitted that in previous occasion the petitioner had filed made case number 31 of 2014 before the court of senior civil judge Barber, disclosing the cause of action which arose on 2/6/2013. Such suit was dismissed on merit on 8/1/2016 on the ground that there was no cause of action to bring out the suit. The finding of the lower court was confirmed in Mata number 2 of 2016, thereby dismissing the appeal by the petitioner appellant in the court of district judge Barkad on 17/2.
So now stop there, Mr. Sahoo. You are Mr. Mahanti. Sir ko na
Panda.
So Panda, now whatever you have said till now, the court has exactly taken note of that. At least you should be satisfied with that. Court has considered it. Then kindly read further, Mr. Panda or Mr. Sahoo. Though the petitioner preferred MATA.
Matta number 30 of 2021 before the Honorable High Court of Orissa, the same was dismissed as withdrawn. Subsequently, the petitioner has instituted the present matrimonial suit upon the very same cause of action, which arose on 2/6/2013. It was taken by him in the previous made suit bearing number 31 of 2014. As the finding of the made case number 31 of 2014 stand confirmed. The present suit instituted by the petitioner stand devoid of cause of action. Hence, he has prayed to reject the plaintiff petition bring devoid of cause of action.
Yeah. अरे पढ़िबे ना मु पढ़िबे ता जो कहे मते कहिबे ना तुम कोन करी.
On the other side, the petitioner has objected the petition by submitting that instant made suit the respondent had on dated 28/11/2022 file an application challenging the maintainability of the proceeding on the same ground, and same was rejected by the court on 14/2/2023, against which the respondent has preferred WPC number 35543 of 2023, which was finally disposed of on 4/1/2024, with a finding that question of maintainability being mixed question of fact and law will be decided at the time of final disposal of the case after trial. Thus, the respondent in a habit of filing vexatious petition repeatedly.
So in the same case, Mr. Panda, there is already a decision by the High Court.
Yes.
So have you challenged that in Supreme Court?
This honorable court that
Unless you challenge that, because in fact now you have realized what the court has. One thing you can be sure that I am reading with you. I am not माने पढ़ी के आगुरु प्रिपेयर है कि आपन क्वेश्चन करछ सेमति भाबंतुनी. I never do that. I try to read with you. Maybe I am little faster or slow, that's a different thing. So already there is a determination. It is always a mixed question of fact and law. I was asking you that if somebody has already proved something or suffered a judgment and it has been adjudicated, your approach should have been different. But somehow in Order 7, Rule 11 application, you have written res judicata. What's to understand? Because the A is very specific where the plaintiff does not disclose a cause of action. your desertion, the allegation is against you is desertion, mental cruelty, and having illicit relationship. These three are the allegations. So if you are saying that those allegations were made and this have been disproved or it has not been entertained, those allegations have been rejected by the court, then at what stage you can take that plea? At the stage of filing plaint or at the place of mixed question of fact and law, what the court has held? Then kindly read further. Read further. High Court has decided.
Whereas the record in the present petition at its appear, the petition respondent has claimed that as the earlier suit stand decided with a long finding that there was no cause of action to bring such suit, and the present suit being subsequent one each devoid of cause of action, as the petitioner had taken the same cause of action. It is also found that earlier the petitioner respondent has made a petition challenging the maintainability of the suit on the principle of res judicata, where under such initiation of previous suit was discussed at length by this court. The respondent has challenged the order of this honorable court before the honorable High Court, wherein this honorable court has directed the party to participate in the trial, adducing evidence where upon the issue of res judicata shall be decided along with the other issue on the basis of material available on record. Such being the present scenario, it appears that the petitioner respondent again trying to agitate the same matter under the wish of the provision under section 7 of order 7 rule 11 of CPC, hence the present petition.
So Mr. Sahoo, Mr. Ponda, so without reading this also, I have assisted you that you are arguing res judicata. Though Mr. Ponda is trying to explain that it is not, you have already argued that the problem is for you is that you should not have. You should have avoided that. You could have raised that plea at the stage of filing your written statement. But now you have suffered that High Court judgment.
I have read the results.
Sorry? So you have to go to Supreme Court, not again by filing Order 7 Rule 11. High Court judgment in writ petition, because it's interlocutory, so it is writ petition, not RPFN. So that cannot be re-agitated by the self-same ground by 711. Suppose now, have you ever seen an order being passed in Order 7 Rule 11? No cause of action. Because Section 13, cruelty, desertion and having a relationship are specific instances in 13. You may have a very good case in defense, but what you have, the problem is that you have attacked it in a different manner. Second attempt cannot be made like this. Suppose apart from Order 7 Rule 11, you can file another application, say 151. Inherent power you will invoke. Again another writ application here. Court will reject that. That is not possible, permissible also. Because in the Order 7 Rule 11 application, you have said that the self-same cause of action was decided and finally decided by the High Court. MATA has been dismissed. Suit dismissed, appeal dismissed by the district judge, then MATA dismissed by the High Court. That the High Court has said that it cannot be decided because it's a mixed question of fact and law. I don't know whether High Court has referred to Section 13 because Section 13 application, because today no court can decide tomorrow whether cruelty will happen or not. Because it is more, you can say it's a dynamic thing. But suppose partition, money, any kind of declaratory relief, they are decided once for all. But 13 cruelty today can be, no, not today, one can be cruel tomorrow. One who is having company can desert tomorrow. So that is another, so the court has already decided.
Thereafter, reduce evidence, my lord. Initial stage, the Order 7 Rule 11 was filed. Thereafter, the petitioner filed these orders, all the document and the deposition of the petitioner was also taken into consideration.
Actually, to my understanding, though I have not practiced much in trial, you had a better case in defending your case than entangling yourself. You yourself have entangled in Order 7, Rule 11. Res judicata you have once raised. But a res judicata cannot be in a, because unless the other side, wife, the husband, suppose now let us assume Mr. Sahoo and Mr. Panda, the husband exactly reproduces the plate. Then you simply write that they already considered. So why you will file a 711 application?
To get the plan rejected.
How can you? Because you are yourself showing that para 1 what you have written is the specific cause of action. Desertion, cruelty and adultery. Suppose the husband is alleged of adultery. Today it is dismissed. Tomorrow he commits adultery. Res judicata. So that you have invited that adjudication. But you could have simply written in your written statement that he made an allegation of this on that date and this has been dismissed and all these things. Actually, since he is there, the court should not speak much about the points in favor or against both of you. Because what is ultimately happening, that perhaps you will be better educated to argue your case better, which he may not like. As a lawyer, he may like it, but as a party, as the petitioner, whether you will like it, that how you will defend your case, the court is educating you. So nothing left, Mr. Sahoo, Mr. Panda. तापरे आपण तो कहउछन the suit has progressed further. Evidence is सरलाणी. 711 पर कोन हला stay हितला it?
No stay.
It haboni bi kaina apanakara the other problem is that this court cannot reopen it. It is binding on me also. The coordinate bench in the writ application saying that it is a mixed question of fact and law, that is binding on this court. Even if you suppose assuming that Order 7 Rule 11 is another petition, what is High Court order ta kain? High Court judgment ta koti achi?
Not an extra.
Into apanakara, if you read 18, Mr. Sahoo and Mr. Panda, the trial court though has not referred there. The other side, the petitioner has objected to the petition by submitting that the instant mat suit, the respondent had 2811-2022 filed an application challenging the maintainability of the proceeding. Same thing, same language. The petitioner herself is a lawyer.
No, ma'am.
She doesn't understand. You have to give the legal opinion on this. ଆପଣଙ୍କ ଫେଭରରେ ବି ଏଟା ଅଛି ଆପଣ ବି ପଢିଲେ ତାକୁ ବି ବୋଧେ ପଢି ନାହାନ୍ତି ପେଜ 20 ପଢିଲେ ମିଷ୍ଟର ପଣ୍ଡା and ମିଷ୍ଟର ସାହୁ ପେଜ 20 ଟା ଆରମ୍ଭ ପାରା ଆରମ୍ଭରୁ ପଢନ୍ତୁ 19 ର ଲାଷ୍ଟ already had ସେଇଠୁ ପଢନ୍ତୁ
on dated 28/2/2025-24 filed by the respondent and objection thereto. The respondent has submitted that Honorable High Court of Orissa in WPC number 35543 of 2023 directed the party to participate the trial by adducing evidence whereupon the issue of res judicata shall be decided along with other issue on the basis of material available on record.
So now this is already there in your favor. Have you missed? You have missed it completely. Then kindly read further.
even though there is no dispute regarding the draft issue as filed by the respondent, but the petitioner has denied some issue in his examination in chief by way of affidavit. Thus, issue need to be recasted as one, whether the suit is barred by the principle of res judicata or constructive res judicata, whether the suit is barred by the principle of estoppel, or whether the suit is barred by the non-joinder of necessary party under Rule 5A of Hindu Marriage and Divorce Orissa High Court Judicature 4, whether the petitioner is entitled for decree of divorce basing on a period of more than 8 years of separate living of the party and other issues.
Mr. Sahoo and Mr. Ponda, what more you will get? I was discussing with these things only.
My lord,
Every issue has been included in your favor.
no, my lord.
Are कोटा नो माय लॉर्ड कहउछंती
This issue has been recasted later on.
पढंतु ठीक अछि पढंतु
Estoppel is not an issue. Yeah.
आपण
Rule
धरंतु मिस्टर पंडा धरंतु एस्टोपेलटा इश्यू नथिला हबन but can you not confront in your cross examination or examination in chief in state like this then पढंतु ठीक अछि मिस्टर साहब पढंतु आपण on the other side
the petitioner has objected by submitting that as the issue regarding the maintainability has already been framed and it is not necessary to recast the issue. Submitting further that the respondent is deliberately filing various petitions repeatedly. The present one, the record reveals that the issues were recasted on 14/2/2023 and recasted issue including one, whether the met application in the form of suit is maintainable in the eye of law. Second, whether the petitioner husband has cause of action to file such application in form of suit. Third, whether the met application in form of suit is barred by the principle of res judicata and constructive res judicata. Fourth, whether the respondent has deserted the petitioner. Fifth, whether the petitioner husband is entitled to any other relief. Hence, it is seen that the proper issue, whether the suit is barred by the principle of estoppel and is bad for non-gender of necessary party to relate to the maintainability of the met suit, and the same can be addressed while deciding the issue relating to maintainability of the suit. As regard purpose, issue number 4 in
Sarla, so Mr. Ponda, you have not understood then, because on 14/2/2003 these issues have already been recasted, and the court says rather they will challenge, they may challenge, I cannot say, they should not also, by instigated by the court. Proper issue whether the suit is barred by the principle of estoppel and barred for non-gender parties relate to the maintainability of the mat. So that is always the issue the court has itself said. But separation, Mr. Ponda, as I was telling you, separation, long separation itself is a cruelty. Now it has been held by Supreme Court in some decisions. Long separation, if you go to that Justice Bhandari's judgment, is there at least. That cannot be a res judicata also. But anyway, the court has entertained your res judicata, then why you are challenging this order, which is in your favor? So disposed of. Yes, anything to say?
No, ma'am.
Have you looked at paper?
Yes, your lordship.
So that helps you.
Madam.
In the sense that you at least you know the pleadings and
Yes,
what
Lord.
has been discussed. Yes.
Got an idea, ma'am.
So Dilip Kumar Sahoo and Mr. A.K. Ponda for the petitioner. Mr. Agnihotra Sahoo for the opposite party. The petitioner wife before this court, the petitioner is the marriage, is the wife in the marriage. She is before this court challenging the order passed by the learned judge family court, Borgard, in MAT case number 71 by 67 of 2021, dated 3/7/2024. The said order is has been passed
3/7/2024.
No. The said order has been passed for in an application filed by the wife in the marriage, who is the respondent in the MAT case. So syntax accordingly. Filed under order 7 rule dash 11 of CPC by the wife in the marriage, seeking rejection of plaint. The copy of the application under order 7 rule 11 filed by the petitioner hearing is annexed to the writ application marked as annexed 2. Paragraph 1 and 2 of the said application are reproduced here. Stop. The learned counsel, Mr. Sahoo and Mr. Ponda, were heard at length. The learned counsel, Mr. A. Sahoo, for the opposite party, submits that he doesn't have a copy of the application. However, he has gone through the paperless brief being available. Stop. The learned counsel, Mr. Sahoo, reiterates the submissions made before the learned trial court, that the trial court should have rejected the plaint as sought for by filing application under order 7 rule 11. For convenience of reference, order 7 rule 11 is reproduced here in 11, rejection of plaint dash and small a. Tapare chaki mate. At least 11a कुछ तीन धाड़ी quote कर para. Since the order 7 rule 11 into bracket small a provides that the plaint shall be rejected where it does not disclose a cause of action. The learned counsel for the petitioner were asked to go through were asked to place on record. No. Were asked to apprise this court whether the plaint discloses any cause of action or not. In that context, the learned counsel for the petitioner have placed the relevant portion of the CP, relevant portion of the MAT case number 71 of 2021. For the dismissal by 71/67. Yes. Of 2021.
3/7/2027.
Filed on?
Madam?
If suit ta kebe file la, plate ta kudino file la, date ta.
10.
Filed on dash lekhi tha, jodi mudibo lekhi ho, nol nahi ho.
Filing ta mention he.
7 October 2021.
Madam.
Filed on 7 October 2021. Stop. ये 7 अक्टोबर तो नहीं, कौन 21 एक लिखा है। मैडम 21/1/2021 fixing date of appearance on 26/11/2021. है ना? Stop. The relevant portion of the impugned order is reproduced herein. जो relevant portion पूर्व लिखी हुई. The learned Judge Family Court has considered the petition invoking Order 7, Rule 11, dash small a into bracket small a. Rule 11 dot into bracket small a. By Rule 11 into bracket small a. The objection filed by the opposite party, who is the petitioner herein, who is the petitioner before the learned trial court, and has passed a detailed order. The page 19 Rachi, peruse the record in the present petition up to for hearing. Perusal of the above paragraphs and the reasonings given by the learned trial court is that the learned family court is that on 14/2/2023 the issues to be answered in the MAT case have been recasted. Stop. The issue regarding maintainability of the application will be heard by the learned trial court as indicated. Stop. The objection regarding maintainability as indicated in the application under Order 7 Rule 11 is also available to the petitioner to be raised. The learned family judge has also taken note of the fact that the present applicant, the present petitioner, as respondent before the family judge, had filed application on 28/11/2022 challenging maintainability of the proceeding that was rejected by the court, rejected by the family court on 14/2/2023 against the said order dated 14/2/2023. WPC 35543 of 2023 was filed by the present petitioner, which was disposed of by this court by a coordinate bench, observing that maintainability being a mixed question of fact and law will be decided at the time of final disposal of the case after trial. Stop. In considered view of this court, the said decision by the coordinate bench, having not challenged, also binds the present adjudication. Stop. The petitioner is also no way prejudiced, as the learned family court has recasted the issue and kept all the issues open to be considered during course of trial. Stop. The writ petition is accordingly disposed of. It is clarified that this court clarified that no part of this order shall be treated to be observation on merits of the contentions of the parties to the litigation which is pending trial. Yes. Great. Council also. Yes, please. You are Mr. Chaudhary.
No, sir, Your Lordship, the council act which has been changed.
Sorry, sir.
I am Soumya Ranjan Sahu. Actually, previous council has not given the NOC. That's why we have filed an affidavit for a change of council.
So that cannot be done, sir. Without consent, I cannot hear you.
But Lordship means
This game cannot be, court cannot be a party to that. The petitioner has to appear in person. You are the party or you are the lawyer?
I'm the lawyer.
So the petitioner has to appear and say that.
Okay.
Don't.
Next hearing,
The problem is that if you do that, it will be because unnecessarily you are entangled.
Yes.
Because that will amount to may not be misconduct, but not appropriate for a lawyer to appear where other counsel is appearing.
Yes.
Because same thing will happen to you.
Yes.
Tomorrow, Mr. Mohanty, because he sits every day, he will be engaged in every case. So don't do that. But let us see. You are for the opposite party here,
Yes.
Ankur Agarwal.
Yes. Lordship.
By which order you were granted? Have you read the brief? I think without reading the brief, I am much better prepared because I found whatever I told you. That is correct.
Proceeding has been. I also went through the order.
The proceeding, if the proceeding is stayed, but you are saying the vegetation right order has been stayed, there is no such order by this court. By which order you have been granted vegetation right? You have to check that. These basics you have to be on your fingertips. Whenever you are preparing a case, you must know what is the impugned order. If it is in the nature of interlocutory order, then more so, then what is the prayer? Then what was the interlocutory order? First in which application? You have heard now Order 7, Rule 11 was argued extensively, and both the council gave, three of them gave much time also. So you must understand that. So because you are saying that your right to vegetation has been stayed by this court, there is no such order. This is a TRPC. I suggested you that because if a interlocutory order is challenged, it cannot be a TRPC. It has to be a writ or a RPFA. Revision or writ. And regarding you are Mr. Soumya Ranjan Sahu.
Yes.
But you have appeared without obtaining consent.
Lordship, he has denied to give the consent. That's why you have filed an affidavit for the change of counsel.
You should have
And it has been attested.
one collector. Because it's not listed. I started dictating the order as if it is in the list. It's not in the list.
Yes.
First of all, you know what you want. To want a particular order of vacation, then that order is not stayed any interim order. Proceeding has been stayed.
Oh, yeah, sure. Thank you.
Because if they have not sought for stay of any order, the court will not grant it.
Yes.
So you can check it, right? So what do you want?
I think you're also only the mentioning of the transfer petition order.
Because you don't have power without obtaining consent. So that defect, there is a defect or defect. That the registry will show as a defect. What is it? That is not a good thing for that. Those kind of observations regarding a law is not a good thing. You should avoid them.
Yes.
Also, this one.
Item 5,
Also,
7, 8, 9,
Yes.
Item 7, Your Lordship. Item 7. Yes, Your Lordship. Let the present petitioner file the transfer DB petition. Sorry, sir. Bonaja Ponda. Yes.
Yes.
Yes, Your Lordship. The present petition filed this transfer petition for
Now declare.
Yeah. That's what again I will get the.
So you have to be because this will be reflected in the cause list.
Yeah, I
Because
will
the
get that.
registry doesn't have authority to accept document. And you talk to your client that which order actually you want to challenge. Yes. Now, Saja Babu second GP. The Bhakti. Yes.
Yes, Your Lordship. My Lord, the present petition is filed for the transfer of the DB petition number 46 of 2026 from the Court of SDCM Jagatsinghpur to the JMFC City. As the present petitioner has also filed one DB petition number 145 by 2025, Your Lordship. Once after receiving the notice and after appearing in the DB petition, the yes, sir.
If you read DV, then the mother-in-law is terminated, then she has to go to the nearest school. Because DV petitions do not work in different jurisdictions.
Yes, sir. Earlier, I have filed
report. That protection officer,
yes, sir.
they are all local.
Yes, sir.
I hope to understand what I am saying.
Yes, sir.
Mother-in-law, where she has been terminated, as per her allegation, she has to move that to.
Yes, sir. The scenario is I have filed the DB petition in the present Cuttack, JMFC Cuttack. After yes,
Sister-in-law will file against you.
Yes, sir.
You will say that all DB applications transferred.
No,
They will say that then why not your transfer because she is senior lady.
yes, sir.
Your mother-in-law was agent than you.
No doubt she is agent lady, Your Lordship.
But the approach is
Your Lordship, kindly.
you are not in the same state where you are serving others. That is the problem. Now, which court will decide that DB petition by mother-in-law should be at a place where the sister-in-law, sorry, daughter-in-law resides?
My Lord, he has appeared in present DB.
So jurisprudence are not developed like that.
She has appeared in
It has become equivalent. Because DB is for since all ladies can file your mother-in-law, sister-in-law, everyone will file.
Let's say in Annexure 1, her DB petition is there, and it has in the verification, it has been verified in Bhubaneswar.
Verification does not make jurisdiction.
Yes, sir. But
if you must understand you are having law here. Passing observation is decided. It's serious. Never make any submission which does not have any legal value. You can verify that in America. Better.
my Lord, I have filed one IA also. IA number 39 of 2026. Yes, sir. Both will be state. Yes, yes, sir.
The petitioner is the daughter-in-law of the opposite party, mother-in-law. Mother-in-law is aged about 66 years, daughter-in-law 25 years. The mother-in-law has filed DD number 46 of 2026 before the Lord SDCM Jagatsinghpur. Under section 12 of the DB Act, Prior thereto, the petitioner daughter-in-law had filed EV case number 145/2025 before
Because JMFC city cut.
JMFC City Cutter. The daughter-in-law wants the mother-in-law's EV case has to be transferred to Cutter. EV Act does not provide, does not have any such provision. That wherever the daughter-in-law lives and she is the alleged the domestic violence case by the mother-in-law. The domestic violence case has to follow her. Hello. Notice is issued on the question of admission to the opposite parties. To the opposite party. Indicating that matters shall be disposed of at the partition. Equities for issuance of notice by state court with gestation and proof of delivery filed within 5 or 3. Within 5 working days. Written labor date be fixed to for capable of trade. For
Odisha.
Odisha location. Written labor date be fixed to 6 7 24. The matter shall be listed for orders in the week of which Odisha locations.
Yes, sir. I have filed the IA. I number 39/26. I have filed today only. It is displayed in the case details. So course. High Court website. I
Register.
Okay. According to the book, so that's it. Okay. Yes, I'm going
Okay.
So, so you better will take up after this. So, I'm going to
As your lords.
yes, rest of the matters after this. Wherever it was.
Well, it's my apologies for the other court matters.
So, I need because the facility to be to hear from you.
Yes.
So, I have recorded that you object for adjournment.
I did not. Because here, my lords, we have the two things I wanted to bring your lordships was we are questioning the maintainability, and there is an order of this on. Yes. That has to be heard, my lords. It has to. Yes. 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 So, lordship, yes. Yes. Yes.
Whenever you are suggesting that the matter is to be heard, after a past.
Yes. That is what that. Yes. As your lordship. I'm grateful that your lordship.
Please law.
Yes.
To be the logic is law or not? It is law. Then we are very fair.
Your lordship. Yes, your lordship. Item 19. We have removed the defect and the present petitioner is not in contact with us anymore.
So say the restaurant. So I would say from the way through Bhubaneswar. Without consent, mention the factor. Out of the fact that really moving the lawyers was understand. Right there is letters, communicate or 5 years. The taps with the registered letter scope of delivery. And that not a scope. No instruction this process.
Yes, your lordship.
But without the same side, they will say that I did not instruct the lawyer to appear and say that was.
Yes, your lordship. We will do that.
So, if you remove, you want listing for fresh admission or
Liberty may be passed, your lordship.
fresh admission after the.
Your lordship.
Remove the.
Last date, your lordship, on 17.
Last week.
Yes, your lordship.
I'll pass that. Share it with you.
Your lordship, actually, the present
name is?
Smruti Pragya Pradhan. Yes, your lordship. Your lordship, actually, the present petitioner is 70 years old and the opposite party is already married. So that maybe that's why the present petitioner is not contacting us.
He's challenging a written order.
Yes, Your Lordship.
He has to pay till she gets married. 129 is very clear. Marrying does not defeat the earlier order.
Yes, Your Lordship.
There has been a 125 proviso. After marriage, the entire amount has to be refunded. That is not there. The law is that till she gets married, she will get it. Same with section 25 also, permanent alimony. Or maybe domestic violence, I am not sure. So, is that till she gets married for the period and if the order is prior to her marriage,
Yes, Your Lordship.
then she is to get maintenance.
Yes, Your Lordship.
Or a difficult.
Ultimate तेरह साल.
The registration verify and proceed. If the defects have been removed, it shall be listed. Shall I record that despite your efforts, the petitioner is not responding?
Yes, Your Lordship. Obliged.
No.
ये नंबरটা কি নিকলে মনে আছে নম্বরটা সমালোচনা নিকলে সত্য সমালোচনা কি সমালোচনা করে দেবে তো ফের অর্ডার টিকে রয়ে যাচ্ছে So we'll be going for some days. In view of the energy crisis, we are going virtual. So all of us in Odisha, I don't think that it will be difficult because we have been virtually operating for quite long actually, since 2020. 7টা কোজাইন ডেকটেশন নিয়েছিল এটা খালি আসিব কি অଛନ୍ତି ଦେଖିଲେ କି আপডেট করছেন না আচ্ছা নেক্সট ଅନ୍ୟ ଅନ୍ୟ ଅନ୍ୟକୁ IA 39 of 2026. The IA has been filed by the petitioner and received in the court from the registry during course of hearing. Now, I brought in counsel for the petitioner. She reiterates her submissions as noted above. So, as an interim measure, it is directed that the DB case number 46 of 2026 pending before the Learned SDJM Jagat Singhpur. Returnable date केवे दीचंदी मन पड़ुଛି
हाँ 6 साल. पूरे छत में आछो.
पूरे 17 shall be adjourned beyond 27/7/2026 as would be to a date as would be convenient to the learned court in season of the matter. The DV case number 145 of 2025 pending before the learned JMFC into bracket city Cuttack shall also be adjourned beyond a date 27/7/2026 as would be convenient to the learned court in season of the matter. Copy of this order shall be forwarded to both the learned courts by the registry. Yes.
Azor item 5.
So Devendra Narayan Patnaik for the petitioner.
Yes, arguing out of matrimonial dispute matter against the judgment passed by the non-panel judge by the wife matter. The petition has been filed against the judgment.
Kindly look at the order dated, it was heard earlier. Order dated 34/2026.
Minor.
Just click the bookmark and touch the order to show you.
My lords.
You can refer to paragraph 2 where your submissions have been noted. Para 1 in the facts.
Hmm.
Para 2, can you read para 2 onwards?
Para 2. Regarding the shocking issues, those were raised with the government judge committed reason. I'm not been talking.
So your submission has been noted. That is your submission. Then kindly read further.
In response to the same, non-counsel for the petitioner was requested to offer the readings of the payment petitioner in the opposite party as well as the evidence that the non judge from the court. The counsel is also authorized the decision of the apex court celebrating the deliberating the scope of revision. No. Simon Philip versus Sahid Khan.
Yes, read further.
Council also appraised the decision rendered by the Honorable Apex Court in Rajins versus Neha. Another. In this case, no. My plea was
पूरा पढ़ू ना आती microphone
the law therein in view of the
contention raised that the
contention
wife
raised
is working and earning, so she is not entitled to grant of maintenance.
My lord.
So that has been answered by the apex court.
My lord.
So then the Lord Counsel has adjournment to obtain instruction in the matter and advance further arguments.
My humble submission, my lord. At the time of trial, the wife was not in service. After getting decree, they found that she is obtaining a job.
So can that be a ground for revision?
No, my lord. That
cannot be.
No, my ground is there. My service was terminated prior to filing of this case.
Your ground before the trial court, not before High Court.
My lord.
You see, I don't have the jurisdiction of revision is very limited jurisdiction. I cannot have a different view. I have to decide based on the evidence before the learned judge family court.
Yes, ma'am.
So whatever was there before the family court, that much I can look into.
Ma'am.
Now the rider is, if you have read, I don't know whether you have read it because you are unable to pronounce the names of the parties also. So most likely you have not read. It very clearly says that High Court cannot interfere because it thinks differently. Suppose on the same facts and circumstances, I would arrive at a different conclusion. Even that also I cannot do. Because so you have to look, you have to place because there is nothing. There is nothing on record to show that what you are saying.
I have additional in my evidence before the trial court.
Adducing of evidence cannot be a matter of debate or speech. It's not a debate competition. You have to show from the records.
Yes, ma'am.
Where is that?
I have evidence, my lord.
Where is that? I don't find. My brief is not having that. If you are having it at your home or with your pocket or with your file.
Actually, accidentally put copy
accident of evidence is not. Lower court counsel I
have received a copy of the evidence.
अच्छा फाइल करंतु सेमती बढ़ांतुनी आपण जहा चाहुचंती कोटे जोटा फाइल करथिले सेठी कोन एग्जिबिट हेतला आपणकर कोटा पढुचंती एविडेंस को कोन एग्जिबिट कोन हेतला
एविडेंस
एग्जिबिट केते
मु एग्जामिनेशन
इन चीफ आपणकर
चीफ एंड क्रॉस
आपणकर चीफ एंड क्रॉस
मोर अछि से
आपण चीफ रे कोन आपण चीफ ताकू सेटा
चीफ रे मु कहि छी prior to filing of this case police case 490 case was initiated
help you sir आपण जदी चीफ रे कहले मोर तबार नै तितरे कोन कोर्ट रे इंप्रेस हि जिवे
नहीं तबार नै मोर देयर इज नो इनकम my daughter is with me I am maintaining it, I have been maintaining it to my daughter.
डॉक्टर को मेंटेन कले वाइफ नॉट एंटाइटल सेटा तो नाही ना
ନାଇଁ ସେଇଟା ମୁଁ କହୁନି।
ସେଇଟା ଆପଣ ତାଙ୍କୁ ପଚାରିଥିଲେ କି
I have
ଆପଣ
no income.
ଉଲ୍ଟାଟା ବୁଝିଲେ ତାଙ୍କର ଚିଫ ଅଫ କ୍ରସ ଆପଣ ଦେଖିବେ
ତାଙ୍କ ଚିଫ କ୍ରସ
ତାଙ୍କ ଚିଫ ରେ ତାଙ୍କୁ କହିଥିଲେ ସେ କଣ ଉତ୍ତର ଦେଲେ ଏନିୱେ ଆପଣ ତ ନାହିଁ ସେଟା ଆପଣ ଫାଇଲ ଦ ଲର୍ଡେड କାଉnsel ଫର ଦ ପିଟିଶନର refers to the earlier order dated 34/2026 and submits that he has obtained the copies of the examination and chief of the petitioner hearing, who was the opposite party, as well as his cross examination before the Lorded Judge Family Court. He shall also rely on the examination in chief of the opposite party wife and the cross examination. This further stop. He further submits that he shall place reliance on the written statement filed by the petitioner hearing. कोडी objection ने कोडी कहले देखन एनी अपन पर तो नहीं कोचिंग the he shall file the
objection I have filed. Objection I have filed.
any evidence
Evidence का अच्छी
अपन chief का नहीं the depositions relied upon by the petitioner shall be filed before this court. The matter is adjourned to be listed for fresh admission in the week commencing 13/7/2026. Okay.
Passover item 80.
One eight कहले
No, 8.
8 था sorry. तो बसथिले but sitting here. None appears for the petitioner, though the matter is called twice over. Once when it reached, and again upon resumption of the proceeding of post lunch break. The office note put up by the registry indicates that as observed in order dated 1/5/2026, when the matter was heard at some length, the petitioner has not filed affidavit as indicated in paragraph 8 of the order dated 1/5/2026. Stop. To grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing 13/7/2026. Yes, next.
Item 9.
Mr. Rajkishore Swami for the petitioner. Yes, Mr. Swami.
May I please, Your Lordship? My Lord, the petitioner challenging the unreasonable and illegal award of maintenance under section 25 of CRPC in favor of the opposite party wife.
25.
125, Your Lordship.
125.
My Lord, of rupees 30,000 per month since the day of application, and towards the arrear 6,60,000 to be paid in 3 installments, Your Lordship. The case of the petitioner before the lower court, my Lord, that the petitioner is that the opposite party husband is earning 1,10,000 from the business and 1,20,000 from the house rent, Your Lordship. But the key factor of this case, the wife is duty bound to prove the income as required under section 106 of the Indian Evidence Act, Your Lordship. So Your Lordship may see the
So instead of doing that, you straight away go to your pleadings. What you stated before the trial court, whether what you are stating now are stated there or not. Straight away go there.
So I am coming, Your Lordship.
No, better let us save some time actually. I don't know. Today we have slowed down though. Some matters took so much of time, so it should not.
Yes, Your Lordship. I will take few minutes, Your Lordship. Your Lordship may see page number 56.
I'm little bit faster than you. I have got your point.
Yes, Your Lordship.
So we are saying that your contentions have not been noted. So you straight away take the court to the written statement.
My Lord, the
onus of proof, that's a wrong statement.
Onus of proof
that is not there.
On the wife, Your Lordship.
That is not there.
As required under section 106 of the Indian Evidence Act.
Show me the provision in any case law on this, that in a 125
application. Recently, my Lord, Guwahati High Court has the
I am not following Guwahati High Court.
So your lordship,
No,
not,
no, please.
so I am,
So I have to reject that, Mr. Swine. Then the problem is that if you, I have to reject that contention that the onus is on the wife to prove the income of the husband.
so my lord,
Any Supreme Court decision on that.
after going through the,
No, first of all, whether you will rely on the written statement or not.
yes,
Okay, so
I have
written
denied.
statement. That point is well taken. That the onus is on the wife unless she proves the
so my lord,
income of the husband under section
6 of the Indian Evidence Act.
Evidence Act. That 125 cannot be
They
allowed.
have not proved.
Anyways,
PW1 is the
Sir,
wife.
your point is well taken. You don't have to repeat the point 10
Yes,
times.
yes, your lordship.
Let us
My
save
second
time.
limbs of submission, your lordship.
The written statement, straight away go there. Where you have stated that he has not proved the statement and in chief or cross examination where you have asked.
Yes, I am showing the cross examination of the PW1, your
First of all,
lordship. The wife.
first of all, you show your written statement where you have taken this stand, denying the allegation.
I have
Second,
already denied the allegation.
Sir, instead of speaking that, so place it before the court.
Annexure 5, your lordship.
I'm there. When you go on searching, I have completed reading also.
My lord, in para 5, my lord, the
Where you
content,
have said that your income suggested is denied and you are not earning that.
my lord, in para 9, that the contention made in
Contention
para,
ଆପଣଙ୍କର income କେତେ ଟଙ୍କା ସେ ଯେତେ କହିଛନ୍ତି 10 ଲକ୍ଷ ନା 20 ଲକ୍ଷ ସେଟା ନୁହଁ. Where you have stated that you are not earning 20 ଲକ୍ଷ, you are earning nothing or you are earning 1 lakh.
so my lord, it is simply denied that I have
So
not.
that doesn't help. ठीक ଅଛି ଆପଣ ପାରା 9 ରେ ଯୋଉଟା ବି ଦେଇଛନ୍ତି ସେଟା ପଢନ୍ତୁ. ପାରା 9 ରେ
So my lord, one thing I want to draw.
No. You give me 10 things, but let us not spend time in just.
No, I am not spending time.
ଆପଣ ପାରା 9 ଟା ପଢି ଦିଅନ୍ତୁ ଥରେ. Be satisfied with it.
That the contention made in para 11 is true, but the petitioner had voluntarily left.
ପାରା 9 ରେ ଆପଣ deny କଲେ. ପାରା 10 ସେଟା
Para 10.
ଆପଣଙ୍କର staff ଲାଗି ଯାଇଛି.
Yes. That the contention made in para 12, 13, 14 and 15 are totally false, fabricated and hence denied. It is submitted that the opposite party is not a settled business, rather doing small businesses. It is denied that the opposite party is earning 1 lakh rupees per month, and it is also false to say that the opposite party receiving 1,10,000 and 1,20,000 from the house rent per month and having 3 numbers of storage buildings in a different place.
So you have denied that your total income is 3,30,000. Okay. So now how the court has dealt with that? What is your examination in chief?
So my
or have you cross-examined your wife?
Yes. So my cross-examined the wife.
Where you have
my lord
asked this question to her.
My lord, in running page number 57, the cross-examination of the PW1, your lordship. In para 28, I have not filed any document showing that the opposite party is the owner of Biswajit steel pipes and relating to the ownership of 3 buildings.
ଦର୍ଶନ ବୋଲି ଏତେ ପଢିଲେ କଣ ଆପଣ ଯେମିତି ଆନେକ୍ସର 5 ପାଉନଥିଲେ କିନ୍ତୁ ମୁଁ ପଢି ଦେଇଥିଲି ରୁହନ୍ତୁ.
My lord.
କ୍ରସ୍ ଏକ୍ସାମିନେସନ କୋଉଠୁ ଆରମ୍ଭ କଲେ?
My lord, 28 para 2.
17 ରୁ ଦେଖିବା ଆରମ୍ଭ କରନ୍ତୁ. So 13 states you have received 5,01,000. So that evidence is not demolished. para 18.
So
Yes,
my lord,
55. So you have received 5,01,000.
my lord,
Yes.
consistently the father, the OP
Then
number.
kindly read para 20
My,
upon cross examination.
I was staying in the house of the opposite party happily for 8 to 10 days after the marriage. My father retired from the service after 2 months of my marriage. My father was a teacher in a government high school. I have not filed any case when the opposite party demanded cash of rupees 20 lakhs and 100 grams of gold after the marriage. It is not a fact that neither the opposite party nor demanded any money nor has torturing me. It is not a fact that after the retirement of my father, I asked the opposite party to give money to my father, and that I have taken 50,000 from the opposite party and gave it to my father, and I was also taken money from the opposite party in a regular interval. During the reception party of the opposite party number 1, I found that he was consuming liquor. It is not a fact that opposite party has never consumed liquor, that he has never assaulted me in any manner. It is not a fact that 2 maid servants were working in the house of the opposite party, and that during my pregnancy period, the opposite party was not assaulting or ill-treating me, and that I was not compelled by the opposite party to do the household works during my pregnancy period. It is not a fact that after marriage I was not doing any household works, and that I was pressurizing the opposite party to bring the foods from the hotel regularly.
Say, who is
So
who was conducting this trial?
My lord, in Jharsuguda, my lord.
So you can't improve. So now the
So, my lord, I will prove, my lord.
kindly you
So
cannot.
the PW2, my lord,
So
the father relating to.
Sir, let us not jump around. You stay with the first cross examination. Look at 28.
Para 28. Yes, your lordship.
22 पढ़ुଥିଲେ, so 17 ରୁ 22 पढ़िले ବର୍ତ୍ତମାନ 26 27 ଯାଏ.
Yes.
There is nothing which favors you.
Yes.
Rather, you have allowed the witness to cover up everything whatever she has
No,
said.
my lord, these things has been demolished in the cross-examination of the father examined and cross-examined as OPW2.
Under which provision? That are you confronting the evidence of the father with the lady? What fantastic theory you are propounding? That the wife's evidence has been demolished by the father in his cross-examination. The co-provision of Evidence Act.
So, my lord.
So, my lord. So, my lord, किसी provision नहीं.
So, my lord.
आपको पचरा गला जे आपण कोन पचरछन झारसुगुडा जहा पचरछन पचरछन जा गला.
My lord.
आपण वर्तमान कहलेनी जे जेतु से फादर आ गोटे कथा कहउचंती.
My lord.
फादर केमती कहबे वाइफ कर घर विषय आपण काई फादर को पचरछन.
जो relating to the giving of 5,50,000, father has denied.
Whatever.
Father has denied.
Sir, whatever. Why did you ask that
And
question?
demanding of 20.
Why did you? Is it a आपण हेटा क्रॉस एग्जामिनेशन करथिले ना नहीं इन्वेस्टिगेशन करूथिले?
नहीं, father cross examination पचरा हला.
So काई पचरथिले सेटा? Who stated?
Father has given the check. Father has given the check. For 20 lakhs was demanded.
Father जेतेबेले क्लेम करिवे मेंटेनेंस ताकू सेतेबेले कहिबे 125 father क्लेम करि पारे.
That is not the fact, your lordship.
No, you are not following. That is the fact.
That is the fact remains after the retirement of
how can you, the question is very simple, Mr. Swain. You are a seasoned counsel. How can you demolish a witness based on the statement of another witness?
So, my lord,
so my lord, kon? Which provision I am asking you?
So, my lord, I mean contradiction. Contradiction, my lord, 145.
How can you demolish the statement of one particular witness by another statement of another witness? How is it relevant?
So, my lord, negative inference will be done, my lord.
Never, cannot be.
So, my lord,
which provision you are saying
my lord,
that?
1 second, bear with
no,
me, my
no,
lord.
you have to bear with the court also. It is not a one-dimensional speech that you are making a speech. I will not understand or ask.
No,
you.
my lord,
So kindly complete. First, you complete reading 28.
Yes. I have not filed any document showing that the opposite party is the owner of the Biswajit steel pipes, and relating to the ownership of 3 buildings. I have not seen any documents relating to the business and house property of the opposite party. I have not filed any document showing the owning of the opposite party. It is not a fact that opposite party not earn rupees 1 lakh per month and businesses and 1 lakh to 1,20,000 from the house property. It
So
is
she has denied.
She
has
has
not
denied.
filed any document. So now you come to the,
Consistently, she has not filed
so
any
now you
documents.
come to the judgment where the court has taken note of that. Suppose you are saying that the court has relied upon the evidence of the wife to give you the
So,
maintenance.
my lord, I may be permitted to show
You will not
another.
read the judgment.
Yes, your lordship.
So first you come to the gote complete karantu. Let us not jump around.
Yes.
Ei finding re court kon deal kale.
So the judgment, the operative portion of the judgment.
Operative no सीधा कोठी evidence कोठी deal हैला. आपणकर cross examination तांकर chief सी 70,000 मागिले.
Yes.
She deny college and she stuck to her stand. She has not adduced any document. Have you read 28? Do you remember what is it?
Yes.
So she says that I have not filed anything regarding this earning of.
Father is also saying like this.
Not father, the lady.
Yes.
The father's evidence should be demolished. The seta tapan out theory seta. Seta taporu pasiva. Now where the court has relied on that evidence. Look at 79. Page 79. Subpara. Internal page 5.
Yes, your lordship.
The petitioner has submitted an affidavit of assets and liabilities keeping in view the mandate of Rajneesh versus Nehal. So now read para 3, your objection. How the court has dealt with that. अरे 79 थोड़े पाइला पर फिर कौन उठूस ना पाइला हैं
Judgment page, your lordship.
अरे आपण को brief रो 79 80.
Yes.
Judgment internal page 5. Read.
Yes, your lordship.
Just above 3, read the sub 3 lines. The petitioner has
submitted an affidavit of assessed liability keeping in view of the mandates of Rajneesh versus Neha and others and another in 2020 OCR. For contra, the opposite party submitted the written objection, repudiated most of the allegation made in the petition. The opposite party admitted his relationship with the petitioner, but categorically denied that himself and his family members treated the petitioner with cruelty. It is denied that as per the demand of the father of the petitioner, given rupees 5,01,000. Further, it was given so moto by the father of the petitioner. It is denied that opposite party and the family members were torturing the.
So what does it mean? Further, it was given so moto by the father of the petitioner.
Demand करनथले बापा सोमोट ଦେଇଛନ୍ତି.
That is your evidence. Yes, read further.
It is denied that opposite party and his family members were torturing the petitioner physically and mentally. It is denied that they forced the petitioner to bring 20 lakhs and 100 grams of gold ornaments from the father. It is asserted that rather after the retirement of her father, the petitioner was demanding money from the opposite party to meet the day-to-day needs of her parents. Even in one occasion, the petitioner had taken 50,000 from the opposite party. It is asserted that opposite party never consumed liquor. He has never assaulted the petitioner. Further assertion that the petitioner was not doing any household works in the house of the opposite party and 2 maid servants are working in the house of the opposite party. The opposite party denied the allegation of occurrence of 2012-23. It is asserted that the opposite party was borne all the medical expenses and the time of delivery of the petitioner in the hospital. It is asserted that after discharging from the hospital, the petitioner told to stay in her parental house as she feeling comfortable there. It is asserted that after some days, the opposite party and his family members had gone to the parental house of the petitioner to bring her back, but her father had denied. It is asserted that the petitioner has voluntarily left the house of the opposite party and forced the opposite party to cut off all the relationship with the parents and to stay in her paternal house. It is denied that opposite party earns rupees 1 lakh per month from the businesses and any income from the rent on the basis of the
house rent. House rent.
house rent. On the basis of the assertion made in the show cause, the opposite party sought for dismissal of the petition. The opposite party also submitted an affidavit assets liability keeping in view of the mandates of Rajanish versus Naya. To establish the case, the petitioner examined altogether 2 witnesses, tendered 6 documents on her behalf. Exhibit P1, Exhibit PW1.
Exhibit Taku further. On the other hand, OP examined himself as OPW1
and tendered no document on his behalf.
Yes.
The followings are the points for determination which needs the adjudication in order to establish whether the petitioner are entitled to get the maintenance under section 125 of CRPC from the opposite party, whether the petitioner is legally married wife, whether the opposite party having sufficient means, whether the petitioner is unable to maintain herself and her kid. PW1, the petitioner supported the contention of the petition by stating that she is a legally married wife and opposite party. She proved her marriage invitation.
Anyway, upon the deny
No, my lord, I am not denying.
State 25%.
I lodged the FIR relating to the incident happened on 6/5/24. I have not filed any document showing that the opposite party is the owner of Biswajit Steel and Pipes relating to the ownership of 3 buildings. I have not seen any documents relating to the businesses and a house property of the opposite party. I have not filed any document.
So now the court has dealt with the evidence.
Yes.
In fact, either reproduced actually. Reproduced the evidence of the wife. So which you rely on? Which you so kindly look at then para 7. Your evidence. ଆପଣ ପଢିଲା ବେଳେ ଯୋଉ ଉଲ୍ଟେଇ ଦଉଛନ୍ତି ପେଜ ସେଥିପାଇଁ ଆପଣଙ୍କର ସ୍ପିଡ କମି ଯାଉଛି ପେଜ 82 ଆପଣ ଯୋଉଟା ଏବେ ପଢିଲେ ତାର ଜଷ୍ଟ ତଳକୁ ପଢିବେ 82 ର ଲାଷ୍ଟ ପାରା 7 ଆପଣଙ୍କର
OPW1, the opposite party supported the contention of the show cause filed by him. During the cross examination, the witness stated that on 2012-23 the petitioner had gone to her parental house for delivery. During the conciliation before this court, I refused to take the petitioner to my house as she wanted to stay separately.
So you have refused to admit, but you have given a reason. Anyway, they read further, page para 15.
I am having own GST number, so and so. Now this GST number is functional. Now my business is running. I have filed return for the financial year 23-24. This is my GST number, GSTR 9 for the finance.
This is my form GST for financial year 17, 18, 19, 20 सेमती पढ़िबे ना हम जदी सब नंबर गोटी गोटी करी पढ़िबा देन से कहउचंती जे मु 17 रु 24 जाय जीएसटी रिटर्न फाइल कर बस
that has been confronted to the OPW1
आपण
से फाइल करचंती
सुनतो
last
explain कले I am not asking, just complete the reading then page para 18.
I have got a cement and iron rod sanitary items retail shop in ground floor of my building. I am paying GST for the shop. I have let out 1 room in first floor of the said building. I cannot say about the landed property and house property stands recorded in the name of my parents. Neither, para 26, neither I had sent any notice to the petitioner nor I had filed any case.
Seta 125 dakare 27 padantu.
27. It is my duty to maintain the petitioner and our minor son. The petitioner left my house in month of December 23. I was paying 20,000 to 25,000 per month to the petitioner for the maintenance since December 23 till April 24, your lordship. It is not a fact I have not given any maintenance to the petitioner since December 23 till April 24, your lordship.
अरे पढ़ंतु मत नेले कोन हो
So it is a fact that I am running a business.
कोन 30 लिखा है छी that 30 is not so. It is a fact that I am running a business. आपनकर डिपोजिशन न पारा 30 तापर पारा 8
It is a fact that I am running a business.
Yes. 30 ଟା ଆପଣ ମୋତେ ଏସଭଳି ଦେଖାଯାଉଛି। Then para 8 ପଢନ୍ତୁ।
The Lord and counsel for the petitioner during the course of the argument submitted that the petitioner is the legally married wife of the opposite party and she has no...
ଆପଣଙ୍କ argument ସେଟା ଏବେ ତ
Yes.
ଠିକ ଅଛି। Then come to para 9 finding କଣ ହେଲା?
All the points of determination are to be taken together for adjudication for the sake of convenience of the proceeding under section 2125 of CRPC, which provides the maintenance of the wife and children of the parent. It is not a criminal trial, whereas the requirement would be proofs who owns case beyond the reasonable doubts. It is a quasi-civil proceeding where the evidence on record to be considered with the preponderance of a probability. The objective of the said section is to provide immediate relief and to an applicants and prevent destitution and vagrancy. The Honorable Supreme Court in Chaturbuja versus Sitabai has observed that the object of the maintenance proceeding is not punish a person for the past neglect, but prevent vagrancy and compelling those who can provide supports to those.
So straight away, Mr. Swai, since kindly just go to next page, go to page 87.
My lord.
10B. 10B টা পড়ো।
My lord. The word means in the section does not signify only means such as real property or definite employment. If a man is healthy and able-bodied, he must be held to have the means to support his wife. In a present case, during the cross-examination, it is brought from the opposite party, OPW1, that he has got a cement and iron rod, sanitary items, retail shop, and he is having his own GST number, and such the opposite party has got
So your case is that the trial court relied on the evidence of the lady.
Yes.
That she is a ଆପଣଙ୍କର 3,30,000, three-story buildings, and earning from house property, income from house property.
My lord.
That is being loosely termed as rate.
My lord.
That is not the finding of the trial court. So I cannot interfere.
Yes.
On those grounds.
Only one things I want to
the problem
draw the attention of this honorable court.
No, kindly
the page number 93, your lordship. The operative part of
the... you have submitted, the court has to respond or not. Your case is that the trial court relied upon the evidence and treated that he is having 3,30,000, 3 buildings, and income from house property.
No, your lordship.
That is not the finding of the trial court. So I cannot give that reason. You must understand. 10B is not the reason. 10B is solely on the basis that rather the court has noted the evidence of the lady that she has not produced any records. But she has denied. She says that it is not a fact that he is not earning. That's another thing. But even the court has not gone into that. Court has gone into your own statement of having a business, having GST number.
My lord, this is admitted position of fact. My lord, only I want to show the evidence which is not taken into cognizance by the law and court below in page number 93.
Beyond wife or husband kara darkar nahi. After Rajneesh versus Neha, darkar nahi.
Evidence regarding my
problem when you have a weak case, don't make the case further weak by relying on other evidence.
No.
Because you must understand for determination of a 125, it is a summary proceeding. You have just now read that decision.
So, my lord, the income of the husband, my lord,
income of the husband
to be assessed in a holistic manner by the law and court below.
Holistic, no affidavit manner. Holistic galani. After 2021 Rajneesh versus Neha. So now you have found out. That both have them. Whether in Jharsuguda you are not conducting, wife files the affidavit, husband files the affidavit. Your impression that the court is impressed by the wife's statement, it is not there.
No, my lord, documents are there. Only one thing I want
to show. Not relied on that statement of the wife.
So, my lord, I want to place one thing before your lordship. The page number 93, your lordship. 4 documents GSTR have been filed at the instance of the wife, my lord.
Again, upon the same problem,
my lord, my lord.
Mr. Swine, henceforth, I will straight away pass order. I will not give you the chance of explaining. Please explain. Please carry on. 93.
93, only one line, your lordship.
Yes, sir.
that the annual turnover of the financial year one exhibit P6 of OPW1 is exhibited. The annual turnover for the financial year 2023-24 of the opposite party was nil. So I have at the hand.
beggar sir, how does it matter? ଆପଣ 17 ରୁ 24 से फाइल करथिले
ଆଜ୍ଞା
ଆପଣ ଏबल ବଡିଡ ବୋଲି ସେ କହିଲେ ଆପଣଙ୍କର ଛଡ ଦୋକାନରେ ଆପଣ ଭିତ କାମ କରୁଛନ୍ତି ଆପଣ
ହଁ ମୋର ପ୍ରପର୍ଟି ହଉଛି ଏଭିଡେନ୍ସ ରେ ଆଜ୍ଞା ବର୍ଷକୁ 6 ଲକ୍ଷ ଟଙ୍କା
ନାଇଁ ଆପଣଙ୍କର ଯୋଉଟା 6,30,000 ଦେବେ
ମୋର 6 ଲକ୍ଷ ହଉଛି ପ୍ରଫିଟ ସେଥିରୁ ତା ଏଭିଡେନ୍ସ ରୁ ମିଳୁଛି
ହଁ ହେଲା 6 ଲକ୍ଷ ଟଙ୍କା
6 ଲକ୍ଷ ଟଙ୍କା 6 ଲକ୍ଷ ଟଙ୍କା
ହେଲେ ମାସକୁ ହେଲା 50,000 ଟଙ୍କା
50,000
ଆପଣ 25,000 ଦେବେ ନା କେତେ ଦେବେ
30,000 ଟଙ୍କା मेंटेनेंस
ଦେବେ ଆପଣଙ୍କୁ
लॉर्डशिप में 15
देବେନି କିଛି
no your lordship no as your lordship deem fits because I have got other liability your lordship
ଆପଣଙ୍କର ଆଜ୍ଞା ଆପଣଙ୍କର ଯାହା ଦେଇଛନ୍ତି actually it is in a lower side
so my lord another thing
ଆପଣଙ୍କର ପ୍ରୋବ୍ଲେମ କଣ ହେଇଛି କହିଲେ ଆପଣ ତାକୁ ଟ୍ୟାକ୍ସ ରିଟର୍ନ କୁ फाइल କରୁଛନ୍ତି ଆପଣ ଦେଖିବା ପାଇଁ ଯେ whether ଆପଣ 6 ଲକ୍ଷ court has taken a very reasonable view has the court suppose the
yes,
court has gone by the impression has the court calculated your income as per month 3,30,000 court has not 36 ଲକ୍ଷ ଟଙ୍କା ହବ 36 ଲକ୍ଷର 50% ହଉଛି କେତେ 18 ଲକ୍ଷ ଟଙ୍କା 40% ହଉଛି ଆପଣଙ୍କର 36 4 ହେଲେ 14 ଲକ୍ଷ ଟଙ୍କା ହବ 14 ଲକ୍ଷ ଟଙ୍କା ହେଲେ ବର୍ଷକୁ ଆପଣଙ୍କର ମାସକୁ ମେଣ୍ଟେନାନ୍ସ ହବ 1,20,000 ଟଙ୍କା court has given you 30,000
no your
so ଆପଣଙ୍କର ଯୋଉ impression ଯେ court has carried on the impression of so ଆପଣ କେତେ ଟଙ୍କା ଦେବେ
lordship may allowed me 15 to 20,000 your lordship
20,000 ଟଙ୍କା ଯେତିକି ଟଙ୍କା ଟୋଟାଲ ଡିପୋଜିଟ୍ କରନ୍ତୁ
another aspect your lordship is at page number 39 only I have nothing I will place
ଆପଣଙ୍କର problem ହଉଛି ଯେ ଆପଣ you are arguing a matter in division
yes
and here the court has not relied on what you are now relying or arguing
no
yes
so my lord only page number 39 the order of the honorable high court your lordship
4,000 ଟଙ୍କା
4,000 ଟଙ୍କା ମୁଁ ଆଜ୍ଞା ଦଉଛି
ଆପଣଙ୍କର ଯଦି ସେ 1,20,000 ଟଙ୍କା ଦେଇଥାନ୍ତେ ତାହେଲେ ଆପଣ ସେଟା ଆର୍ଗ୍ୟୁ କରିବା ସୁବିଧା ହେଇଥାନ୍ତା
ସେଟଅପ୍ ଆଜ୍ଞା ହେଇନି ଏଇଟା
ସିଏ ତ ସେଟଅପ୍ ହେଇନି ବୋଲି ଆପଣ କେମିତି କହୁଛନ୍ତି ଆପଣ ପଢିନାହାନ୍ତି
ନାଇଁ ସେଟଅପ୍ ହେଇନି ଏଇଟା ସେଟଅପ୍ ହେଲାନି ମୁଁ
ଆଜ୍ଞା ପେଜ 18 ରେ ଦେଖନ୍ତୁ सॉरी आपणकर माने आपणकर रनिंग पेज 18 जे आपणकर रनिंग पेज 92 आपण तो पाउनाती पचार देबे सीधा मु कहि देबी 92 रो फास्ट से लिखि छन 4,000 टका पाउचंती बोली नॉल से आपण 40,000 करछंती 34,000 करथांते
91 पेज रे 91 पेज
91 पेज
yes 92 page. In the, it is a fact that in APL number so and so, the Honorable High Court, by the order dated 2/8/24, has directed to provide the maintenance amount of 4,000 per month to the petitioner till the conclusion of the trial of the city case, my lord, of 2024 pending in the court of the SDM Jharsuguda, in which I was implicated under section 294, 323, 506, 498, your lordship. As such, the aforesaid maintenance amount 4,000 per month is interim and it is temporary arrangement in the conclusion of the trial. City case number 1691/24.
You are rather lucky because the trial court, heavenly court, could not have taken in a criminal trial the amount paid towards the victim. If you read the judgment, it is only 125, 24 Hindu Marriage Act, DV Act, and the Guardianship and Maintenance Act. But still it has taken note of that. I have not observed that. Why the court, suppose the accused is directed to pay any amount to the victim. So can it be a maintenance?
So that needs to be set up, my lord.
Which law? Have you read Rajneesh versus Neha?
No, my lord, I have read it, my lord.
So criminal trial is not included there.
So, my lord, will I rely the judgment one of the Supreme Court judgment?
Which judgment you are relying on?
My lord, Monish Jain versus
which paragraph? Criminal trial 4,000 na koti pai कहउछंती point
my lord only for
criminal trial देखिबे से कहिबे भलो कथा I continue to be a student of law देखो
No, my lord.
क्रिमिनल ट्रायल रे जदी अक्यूज को दिया हबो सेटा एडजस्ट हबो बोली देखन ओ बैटरी ने यस पढंतु ठीक अछि मो बहरे बैटरी ने भलो हल अब
If the appellant husband has paid, deposited any amount of maintenance in pursuant to the order of the High Court dated 21/2/20,
what is that order of High Court?
man interim order, my lord.
Maintenance
In anticipatory bail, my lord.
see money zen re
My lord.
so now this 4,000 has been taken note of. So you are
Yes.
answering. Good point. I say that whether this direction to a accused in a case to pay some amount to the lady, whether can be account, money is then answer there. So now the court has taken that into account at page 92. How can I say that court has not calculated?
So, my lord, man, I may be double jeopardized, my lord.
No, no, never,
I
never.
will pay here, my lord, till the conclusion of the city case, unless my application for bail will be.
ଆପଣଙ୍କୁ ଯଦି 34 ଜାଗାରେ ସେ 30 କଲେ ତାଙ୍କର କି 40 ଜାଗାରେ 30 କଲେ how you are double jeopardy ପଢିଛନ୍ତି 22(5) article 22 ରେ ଯୋଉଟା ଅଛି
My lord.
ଆପଣଙ୍କର 4000 ଟଙ୍କା ତ ସେ ଆକାଉଣ୍ଟ କୁ ନେଇଛନ୍ତି even I doubt whether that can be adjusted because Rajneesh versus Neha doesn't say so. Anticipatory bail, it's a bail condition.
So in a similar case,
So when after you
so what I summarize, my lord, in similar case.
consuming alcohol, when you bait your wife, suppose you get anticipatory bail, against the allegation. The court says that you pay 4,000. That will be adjusted. That will be termed as a maintenance. In money then you show the judgment where it says that the anticipatory bail maintenance is granted. Yes, Badhan. सीट लगा ऊपर का
Para 17 is page 12.
कोई पढ़ू नांती हिंदू मैंने जात को नहीं कि पढ़े नहीं एंटिसिपेटरी बेल पढ़े पढ़ फर्स्ट पैराग्राफ पढ़ो रीड फर्स्ट पैराग्राफ मोर पर अच्छी कॉपीटा
अच्छी मो पर
ताले सॉरी गिव
The present appeal has been filed by the appellant husband against the order dated 21/2/14 passed by the High Court of Delhi in New Delhi's CMM number so and so. In said judgment, the High Court, while setting aside the order passed by the additional district judge Delhi, who declined to award maintenance mandatory to the respondent's wife.
So section 24 of the Hindu Marriage Act.
My lord.
On anticipatory bail कोड कहले मुझे पछले आपण मु पे तो in fact I was impressed I would have dictated
So, my lord, interim maintenance. My
no 24 is interim and I am telling you that rather you are arguing against yourself. Manish then if says that anticipatory bail condition for beating wife you are giving a condition is that you pay 4,000 and then you get anticipatory bail. That will be adjusted. You are citing a decision which I am telling you that section 24 has to be adjusted. And your problem is that we are also not marking this. This is judgment of which year?
2017 year.
So which is the best judgment in your favor?
Rajneesh.
So 17 ne kai apanakara. So my question to you is that if
So, my lord, I have relied another judgment, your lordship, of 2022, your lordship. Only page number 10, your lordship.
22 of which High Court?
Supreme Court, your lordship.
So, there is no other order in 22. Diyantu Anand.
ଦେଇଛନ୍ତି
17 ରେ ଆପଣଙ୍କର ତ much better decision ଅଛି any amount pays has to be adjusted 24 ରେ ଆପଣଙ୍କର ଯଦି 24 କି domestic violence ନାଇଁ thank you that doesn't help ଆପଣ ଯୋଉ point ଟା elaborate କଲେ argue କଲେ ଯେ anticipatory bail ରେ 4000 ଟଙ୍କା first of all first issue ହେଲା ଯେ 4000 ଟଙ୍କା ସେ consider କଲେ court second କଥା ହେଲା ଯେ your argument is that since anticipatory bail ରେ 4000 ଟଙ୍କା ପାଉଛନ୍ତି maintenance adjust ହବ there I beg to differ you say that Manish Jain says that now you produce Manish Jain because battery is not there. It says 24 maintenance. Section 24, 125, then domestic violence, adoption and maintenance. Any amount directed under these provisions has to be adjusted. Point is well taken.
Directed 15 to 20,000
No.
per month, your lordship.
20,000 you deposit arrears, then you get the order.
Yes, your lordship.
Deposit it.
Obliged.
No problem. For that only I wanted to save your time.
Oh,
At least
yes,
we
sir.
could not have argued for 30
Lordship,
minutes.
as obliged, Your Lordship, highly obliged.
Arey, sir, I am also obliged that you gave your time. Because I told you that instead of placing, straight away go to the judgment. If the court has made, suppose the court has made a mistake, court has taken your income to be 3,30,000. You are welcome to argue that. What is the difficulty?
Obliged.
But we do not find that. You take your seat, I'll dictate.
Okay.
The learned counsel for the petitioner is heard extensively. He submitted that. Stop for you. The petitioner before this court is the husband in the marriage. Challenge is to the stop for you. Stop. Husband in the marriage. Stop. He seeks revision of the judgment. Dated 10/3/2026, passed by the Lord Judge, Family Court, Jharsuguda, in CMC number 30 of 2024. The said application was filed by the wife in the marriage under section 125 of the CRPC, into brackets, since repealed and substituted by pari materia provision, section 144 of the BNSS 2023, seeking monthly maintenance at the rate of rupees 70,000 per month. Seeking revision and challenging the order is submitted by the learned counsel for the petitioner that the learned judge, Family Court has not considered the evidence on record adduced by the opposite party, husband, and has also wrongly appreciated the evidence adduced by the wife petitioner to determine the monthly maintenance at the rate of rupees 30,000. To consider the said summation on merits, this court has gone at length in considering the evidence laid by the present petitioner, opposite party. Also, the opposite party petitioner before the learned judge, Family Court. The learned counsel has elaborately placed the depositions as well as the pleadings of the parties before the learned judge, Family Court. Stop. Upon analysis of the evidence, the learned judge, Family Court upon analysis of the evidence and pleadings, the learned judge, Family Court has framed the following issues. जोड़ा को कोट कर देवे। Is contended by the learned counsel for the petitioner that the court has not taken into account the amount of 4,000 received by the opposite party wife as a condition imposed by this court in APL number 7640 of 2024. By a VDA order dated 02.08.2024. The order of this court has been quoted by the learned. No, not order. The statement of the petitioner has been quoted by the learned Just Family Court at paragraph 10F. It is a fact that APL number 76402 page 91 last 92 first up to city case number 16991 of 2024. But say the quotation portion of first para word or second last word that the income of the present petitioner has been discussed and determined vis-a-vis the amount to be paid as maintenance to the wife. At internal page 19 of the judgment, page running page 93. Affidavit of assets and liabilities filed by the OP up to internal page 20, page 94. Is entitled to get maintenance from our father from the father OP. Then tapare other OP pare para 11 te quote kar debe. Therefore, I am of the considered view. Hence, it is ordered. The learned counsel for the petitioner is apprised of the decision of the Honorable Apex Court regarding scope of revision to be exercised by this court, particularly dealing with matters under section 125 of CRPC. As has been laid down in Shamima Faruqi versus Sahid Khan. Citation dated paragraphs 19 and 20. He is also apprised of the judgment laid by the judgment of the Honorable Apex Court in Rajneesh versus Neha, which has elaborately dealt with the contentions raised on behalf of the petitioner husband herein, who was the respondent before the trial court, that whether the wife is entitled for receiving maintenance when she is capable of earning, and considering the employment status, oblique capacity to income of the husband, what can be the amount of maintenance that is to be paid. But the contention of the learned counsel for the petitioner hearing that the court, the learned family court has got swayed by the evidence and statement of the wife that the petitioner husband earns about rupees 3,30,000 per month is not evident from the judgment. Rather, the learned Just Family Court has relied on the evidence of the petitioner himself as OPW1, where he has stated regarding his business, his GST return, his house having been rented out, to arrive at a figure of rupees 25,000 per month for the wife and rupees 5,000 for the minor son. It is submitted by the learned counsel for the petitioner with much emphasis that still the amount of rupees 25,000 for the wife is in the higher side. ଆପଣଙ୍କର ସନ୍ ରେ ବି କଣ୍ଟେଷ୍ଟ କରୁଛନ୍ତି 5,000 ଟଙ୍କା ସନ୍ ରେ ବି 5,000 ଟଙ୍କା କଣ୍ଟେଷ୍ଟ କରୁଛନ୍ତି Sir, you have to be very strict as a lawyer actually. If you deal with your clients like this, somebody comes and tells you that you will oppose to go to court and oppose the son's maintenance at 5,000.
No, man.
You should tell no.
No.
That way. Though you have not said, I am telling them. What like? I said as directed to be paid to the wife, and the husband is ready, for the time being is ready to pay rupees 15,000, which he shall deposit, calculating the entire arrears till date. Stop. केबे दे परिवे 15,000 टका लेखे
My lord, towards the area, my lord.
हाँ पूरा अमाउंट दे दियंतु 15,000 5,000 पुओ पे 20,000
Henceforth, I will started the payment of.
एरियर मु देबी की
No, your
more don't make my order एक माने laughing
Sir,
stock.
lordship may give it a reasonable time.
अरे आपण पे reasonable के unreasonable सेटा मु तो करिनी. Your client is pretending as if the court has you should have got that instruction. No instruction नहीं
My lord, within 3 months, my lord.
3 months देने 3 months पर notice issue होगा.
3 installment I will started paying.
आपण तो जानी भी ना. I have to now calculate. कौन लिखना? Court stop है till date. The amount due till date is 4/7/24. 4/7/24 है. बारह 10 5 22 मास होचे आपनको कारण 10th में ही गलानी the amount due from किछि पैसा देना
My lord, से 4,000 टका दे चलची तो ऑर्डर हला
अगर बेल कैंसिल हे जो आपण जो बेले बेले निजो जो द ब्रांच जो थ्री यू आर सिटिंग यू शुड नॉट चॉप ऑफ the day you dare not to pay that 4,000 the bail will be cancelled.
I am
You will
paying
be behind bar. आपण काई सेटा आइतरे भर्ती करथिले who advised that council can a bail condition be interpreted to be a maintenance amount? आपण जदि बेल पाई बार्गेन करिवार थिला सेठी करिवे not here. आपण जोडा साइड करछन मनीष कुमार the learned counsel for the से मनीष कुमार साइड करिवे दरकार आपण
No, my lord, I am not.
हां आपण तो रजनीश वर्सेस नेहारे अछते मनीष कुमार 17 मसे फेरी पछु बनउछन सेक्शन 24 has to be adjusted. आपनको जदि कोर्ट रे पेमेंट हेची डोमेस्टिक वायलेंस हो 24 धारा रे भी पारे माइनॉरिटी गार्डियनशिप की अडॉप्शन एंड मेंटेनेंस हेई पारे पॉसिबली बट आपन से अमाउंट किछि नाही कोन लेखिले द अमाउंट ड्यू कम्स टू फॉर 22 months 22 into 20 22 into ब्रैकेट 15 plus 5 20 ना 4,40,000 के आपण किछि पैसा दोना 4,40,000 की देना
Area, my lord, की देनी.
ओके केबे देबे
My lord, within 2 months more, I will clear every area.
फर्स्ट इंस्टॉलमेंट केबे देबे लख टका
First installment, my lord, after 2 weeks, your lordship.
केते दे
1 lakh, your lordship.
तब कोन लेखिले हाँ 4,40,000 लिखिदेले ହେଲା ସେଟା ପୁରା ଲେଖିଦେଲେ ମାନେ 22 ଗୁଣନ ବ୍ରାକେଟ ରହିବ 15 ଯୁକ୍ତ 5 22 ଗୁଣ 20 ହେଲା ତାହେଲେ ସମାନ equal to 4,40,000. The petitioner, the learned counsel for the petitioner upon instruction submits that the petitioner shall deposit 1 lakh before the learned Judge Family Court Jharsuguda. ଆଜି ହଉଛି କେତେ ତାରିଖ? नौ तारीख हूँ 2 सप्ताह ଆପଣ 10 ତାରିଖ ସୁଦ୍ଧା ଦିଅନ୍ତୁ
My lord.
by 10/7/2024 towards areas of maintenance. Thereafter the rest amount of rupees 3,40,000 he shall deposit in
3 installment, your lord.
in 3 equal installments. कितने दिन रे fortnightly ना केते 7 दिन रे कितने दिन
Monthly, my lord.
3 monthly installments. The current monthly maintenance as directed shall be paid by 10th of every month. Upon deposit of rupees 1 lakh by 10/7/2024, the Lorded Court shall pass appropriate, the Lorded Judge Family Court Jharsuguda shall pass appropriate order noting the said deposit, which can be received by the opposite party, wife and child. Stuff. The petitioner shall produce the copy of the order and the proof of deposit by filing affidavit before this court by 10/7 by 15/7 by 15/7/20 नहीं भूल है आपको 2 months डेट पूरा भूल है आपनकर आज होची 18 हेले 10/6 आपनकर 8/6 होची 2 सप्ताह तो 10/6 रे आपण दियौ 10/6 सुधा दियौ डिपॉजिट इन द कोर्ट तापर लिखियो affidavit to be filed by 19/6. The next installment shall be deposited. प्रथमटा केबे देले आपण
1 lakh, your lord.
डेट टा कोन 10/6 10/6. The next the next installment of rupees 1 lakh shall be deposited by 3/7/2024. The next installment of 1 lakh shall be deposited 1,40,000 होगा कौन ताको हिसाब कर देबे इंस्टॉलमेंट हेले रहला 3,40,000 3,40,000 हेले 1,10,000 1,10,000 तीनटा इंस्टॉलमेंट कर दे अपन एक्चुअली हैला सेटा देले the petitioner shall have liberty to deposit the entire amount at one go or shall have the liberty also to deposit the amount before the date as undertaken by this court. Undertaken before this court. Also, last कर दे issue notice to the opposite party subject to the condition as directed above. That is petitioner depositing rupees 1 lakh as the first installment and the rest of the amount in 3 equal installments, monthly installments. Requisites for issuance of notice. ଆପଣ କଣ ଲେଖିଲେ? Issue notice. Issue notice along with this order. Issue notice along with this order. Subject to the petitioner depositing the first installment as directed by 10/6. Purchase and 10/6. And the rest of the installments, requisites for issuance of notice be filed by the requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days. Within 3 working days. Returnable date be fixed to 29/6/2026. The matter shall be listed in the week commencing 6/7/2026. Liberty to mention. आइए कौन पे दी चोटी? Execution file is
operation of the impugned order of state.
Execution file ले आसो.
Delayed execution has
run. आइए देखो तो ISL lie over. Yes.
Much over.
Yes, please.
Item 8.
Author.
Item 8.
8.
Tomorrow the day after.
केवल सेफ्टी हवन
अपडेट फाइल करछि
सेटा फाइल करो तो मेंशन करिवे ते आपण जदी एंतिया करिवे केंति हो सर आपणकर इट वाज कॉल्ड ट्वाइस आई हैव पास्ड ऑर्डर तक करे रिकॉल करी
सेकंड में
आगे
बाहर जस्ट जाई कि पतला
ना
जानि पेली मु बसछि सेत मो ऑर्डर टा डका होतला मु बसछि मु जानि पेली
आपण को मिस्टर जामिनीकांत दास थिले
ताको
so se पळेले तापरे मु देखि so in fact I searched for him
1 second में I am सार को देह कोन हला जी जस्ट बाहर को जाइतिले मु जस्ट पशु
आपण सार को देह कोन हले मोर मुंडो कोन हले असुविधा नो मु बड़ा YouTube रे अछि मते का मुंडो कोन हे गले बुझ पछो कि सॉरी असुविधा का तुम करंतु नि अरे व्हाट इज द डिफिकल्टी आपण जदी सेटा फाइल करछन एफिडेविट मेमो देबे लिस्ट हो आपण को एडवर्स ऑर्डर किछि हेनी खाली लेखा आइछि जे आपण टाइम देबा पे हला जहा घटना घटी से लेखा आइछि सेटा तो हेई सालानी मु अपरे कोन करि आज्ञा
प्रेजेंस में अब अर्जेंट थी ना तो
नॉन अपीयरेंस इज तो लेटर परफ्यूम तो जे ऐड कर देबे लेटर कर देबे कि नेथिले मने अछि जन ठीक अछि हां पिटिशनर मिस्टर नायक मिस्टर डी नायक letter कर देबे मिस्टर नायक appears and submits that due to inadvertence he missed when the matter was called due to inadvertence he was not present when the matter was called though he was otherwise available stop he submits that he will file affidavit during course of the day the affidavit shall be filed it shall be taken on record आपण affidavit की substance अछि की देखियो
मैं कोई ऑर्डर जो देई थी वो डेट सेटा
that is the substance you please take your seat अरे से ऑर्डर शीट काई अरे कोन एंती आपण करछन सब जिंस आपण असिस्टेंट दरकार आपण जोटा एफिडेविट देले ताको सपोर्ट करिवे फेरे पढुना नि कोन लिखछन तार मध्य आपण पर कॉपी अछि एफिडेविट रो
आगे
ताले से करिया कथा पढंतु कोन लिखछन
that I am the petitioner in the procedural case and I just stated that portion order dated direction of the High Court passed by the CRLMC 5296/25. I made payment 2 lakh to the opposite party 1 in cash before the loan judge Tamil Court Berhampur 23/3/2026. As an accommodated man
अरे and as of acknowledgement to that effect she signed in the order sheet of the case record सेटा मु केन जानि
order ta
सेटा त से लगै थांदे
Okay.
ଆଣିକି ଫାଇଲ କରନ୍ତୁ ଭଲ ହେଇଛି ଆପଣ ତ ବଢିଆ ଅର୍ଡର ହେଇଛି ତାହେଲେ ଆପଣ କୋଉଦିନ ଆଣିବେ ସେଟାକୁ ସାର୍ ଆପଣ ବି କେବେ ହେଲେ ଡୋଣ୍ଟ ଡେଭଲପ ଦିସ୍ ହ୍ୟାବିଟ ଅଫ ଫାଇଲିଂ ଏନି ପେପର ୱିଦାଉଟ୍ ଦ ଲୁକିଂ ଆଟ୍ ଦ ଅର୍ଡର ପସିବଲି ସେଟା ହେଇଥିବ ପସିବଲି ହେଇ ବି ନଥିବ ଆପଣ ସେ ରେସ୍ପନ୍ସିବିଲିଟି କାହିଁକି ନେବେ ୟୁ ଆର୍ ଏ କାଉନସିଲ ଆପଣଙ୍କର କଣ ଅଛି ୟୁ ଆର୍ ଆଟ୍ ଏ ଡିଫରେଣ୍ଟ ଲେଭେଲ ଯିଏ ଆପଣଙ୍କୁ କହିବେ କହୁଛନ୍ତି ଅର୍ଡର ହେଇଛି ଅର୍ଡରଟା ଦେଖିବେ ସରିଲା and you file that copy nowadays orders are uploaded those days are gone when ଆପଣ certified copy ପାଇଁ ଦୌଡୁଥିଲେ ବର୍ତ୍ତମାନ ଅର୍ଡର ଅପଲୋଡ ହଉଛି ମାନେ ଏକ୍ସାମ୍ପଲ ଦଉଛି ଆପଣ ଯଦି ସେ ଶୁଣନ୍ତୁ ଆପଣଙ୍କର ସେଟା ବେଷ୍ଟ ପଏଣ୍ଟ ଯୋଉଦିନ ମିଷ୍ଟର ଦାସ ଏଟା ମେନସନ କଲେ ଦିସ୍ ପଏଣ୍ଟ ୱାଜ ରେଜ୍ଡ ତା ନେକ୍ସଟ ଡେଟରେ ସେ absent ରହିଲେ ଆପଣ ଆର୍ଗ୍ୟୁ କଲେ that day you did not raise this have you marked the day order date ଆପଣ 23 ଦିନରେ ଡିପୋଜିଟ୍ କରିଛନ୍ତି but you did not argue that in on 1/5 ସେ କାହିଁକି ଆପଣଙ୍କୁ କରିବେନି why what for then does he not trust you he has to trust you ସେ ଆପଣଙ୍କୁ ଦେବେ କହିବେ ଆଜ୍ଞା ମୁଁ ଡିପୋଜିଟ୍ କରିଛି ସରିଲା କେବେ ଆଣିବେ କାଲି କରିପାରିବେ ଠିକ ଅଛି ସେ ଅର୍ଡରଟାକୁ କିଛି କରନ୍ତୁ ସିମ୍ପଲି ପୋଷ୍ଟିଂ କରନ୍ତୁ ହେଲା ଡେ ଆଫ୍ଟର ଟୁମୋରୋ ପୋଷ୍ଟିଂ କରିଦିଅନ୍ତୁ ଦ୍ୟାଟ୍ ଆଇ ୱିଲ୍ ହେଲ୍ପ ୟୁ ଆପଣଙ୍କର ଯଦି ସେ ଆସିବ ସେଟାକୁ ସେଥିରେ ଲଗେଇକି ସେଦିନ ଫାଇଲ କରିବେ ହେଲା କାଲି ଯଦି ଫାଇଲ କରିବେ ଭଲ କଥା ବଟ୍ କାଲି ନ କଲେ ଆପଣଙ୍କ ଟ୍ୟାଗ ହେଇପାରିବନି
ଖାଲି କଲେ ପରଦିନ ଟ୍ରାଏ
ଠିକ ଅଛି ସେ ନା ଆଣନ୍ତୁ ଆପଣ ଏଇଟା ଡେ ଆଫ୍ଟର ଟୁମୋରୋ ହଉଛି କିବାର 20 ତାରିଖ 20 ତାରିଖ ଆଣନ୍ତୁ ହେଲା ଫ୍ରେଶ ଆଡମିନିଷ୍ଟ୍ରେସନ next please
May I please, Your Lordship? Item number 10.
Item 10.
May I please, Your Lordship?
yes please
Your Lordship, this matter, present petition is filed for the petitioner to transfer the CP case number 52 of 26 that is pending before Family Court of Jagatsinghpur, Your Lordship, to the Family Court of Cuttack, Your Lordship. The present petitioner is staying at
you are Miss Panda
SS Pratihari.
Miss SS Pratihari for the petitioner yes how many cases he has filed against the husband
Against the husband, one DP and one CRP and one DP and one CRP, Your Lordship. The present case is the CP case that has been filed by the husband, Your Lordship. One IA has also filed, Your Lordship, for the stay of the same.
how many cases you have filed
Only a CRP, Your Lordship, and a DV case, Your Lordship. That is pending before SDJM, Your Lordship. Cuttack.
you want transfer of which case
CP case number 52 of 26, there where the petitioner is respondent in that matter.
so your case has to be stayed also
Your Lordship, but I haven't.
you have filed cases against your mother-in-law and father-in-law
Yes, Your Lordship, the domestic violence case that has been filed from
Which
2025, Your Lordship. They have counterly filed that CP after getting the notice, Your Lordship.
how come they will file domestic violence today you are present
Yes, Your Lordship.
today you were present when the daughter-in-law files DV and now the mother-in-law files DV daughter-in-law at Cuttack at mother-in-law at Jagatsinghpur
Your Lordship,
so there you can say but CP cannot be between the mother and the the mother-in-law and the daughter-in-law rather you have got a better mother-in-law she doesn't file any DV case against you who is Subhalakshmi Subhaspita I can't read over written page 19 ne dekhle TRPC 148
yes, Your Lordship.
page 19 ne
19, Your Lordship. Subhasmita Swami is the Prabhasini Raut is the mother-in-law, Your
who
Lordship.
is Subhaspita
She is the sister of the husband, Your Lordship.
sister-in-law
Yes, Your Lordship.
so you have filed against them and you have written the sister-in-law to be son of somebody
Lordship, that has been oversight of mine, Your Lordship.
Oversight in the sense,
There has been
maybe you thought that that will be too glaring, that how she will commit domestic violence staying in her in-laws place.
Your Lordship.
She is married and she stays at a different place. So at least they have not, both Prabhasini and Subhasmita, both have not filed any domestic violence case against you. How do you say that it's a CP can be a counter case against you?
They have filed, Your Lordship, after my filing of DB.
Domestic violence?
Yes, that was in the that is in the matter of item number 7, Your Lordship.
You did not argue 7?
My signet was arguing.
Yes.
They have filed DB case after I filed a DB case here. Then they have filed after
Domestic
getting.
violence has become equalizer actually.
Your Lordship. Your Lordship, she is actually a student, Your Lordship. She is now staying with her father, Your Lordship. Now here at Cuttack.
Who is a student?
The petitioner, present petitioner, Mona Lisa Patnaik. She's 27
I
years
thought
old.
that Subhasmita is a student.
Oh, no, she is a 38-year-old.
Yes, that I marked actually. So when you said that she's a student, I thought that
Look.
she may not be. So Ms. Panda has already got a stay of both the cases. So you have to obtain that stay also. Wherever your case is pending is stayed, and 145 was taken up with that, and it has been stayed.
Your Lordship.
Had learned counsel for the petitioner. The petitioner is the wife in the marriage. C6 transfer of CP number 52 of 2026 filed by the opposite party husband in the marriage. You take your seat, I'll dictate it.
Please.
C6 transfer of CP number 52 of 2026 filed by the opposite party husband in the marriage. Pending before the Learned Judge Family Court, Jagatsinghpur. The CP has been filed under section 13(1) into bracket I-A and I-B, small item of the Indian Marriage Act for dissolution of marriage solemnized between the parties on 27/11/2024 and grant of decree of divorce. Stop. You want to be transferred to Cuttack.
Yes, Your Lordship.
The application, the present application under section 24 of the CPC has been filed, seeking transfer of the CP to the court at Cuttack, Learned Judge Family Court, Cuttack. It is submitted that the connected TRPC 148 of 2026, which was listed and heard today, notices have been issued. The only difference being the said TRPC, now this is 148 connected also 140
TRP CRL 40 of
TRP CRL connected TRP CRL /40/2026. The difference being the said TRP CRL, the opposite party is the mother-in-law who has filed the domestic violence case against the present petitioner. And the present case, the husband is the opposite party. Stop. Issue notice along with this order. indicating that the matter is likely to be disposed of at the stage of admission. So notice to the issue notice to the opposite party, singular opposite party. So requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 or 3 working days. Within 5 working days. Returnable date केबे से मन कहि परिबे 6 से एटा returnable 6 से आते listing 20 returnable date be fixed to 6 7 20 26 the matter shall be listed in the week commencing 20 7 20 26 liberty to mention IA 181 of 2026 issue notice as above. Accept one set of process fee as well as postal requisites along with the petition. Returnable date as well as the next date of listing as directed will be as directed above. Stop. In the interim, it is directed. The CP number 80, bound of 2026 pending before the Lord Judge Family Court Jagatsinghpur shall be adjourned to a date beyond 27/7/2026 as would be convenient to the learned court in season of the matter.
Grateful, Your Lordship.
What to do? Returnable date. लिखा है क्या? ठीक. तो ये स्टैम्प बंद रखिए. ये जो डालने देले मेमो टा. ये नहीं पढ़ेंगे. ये दीदी का मेमो धरी गले था कहीं.
मेमो देंगे.
देले. ଆପଣ ଏଇଟା ରଖିଲେ ତ ପୁରୋଟା କିରି ଫୋପାଡ଼ି ଦେଲେ ତ yes next
Item 11.
Will be permitted to withdraw, madam.
yes please Mr. Ashwini Kumar Das for the petitioner opposite party blank matter was had at length. Matter was had at some length on 31/3/2026 and the following order was passed. Today, the matter being in the list and taken up, memo of date is filed by the petitioner, by the learned counsel for the petitioner. ଆପଣ ହ୍ୟାଣ୍ଡରାଇଟିଂ ପଢି ପାରୁନ ମୁଁ ପଢିଛି ବେନ ବାବୁ ଆପଣଙ୍କ ହ୍ୟାଣ୍ଡରାଇଟିଂ ପଢି ପାରିଲେନି ଗଲା ତ ମତେ କହିଲେ କେମିତି ପଢିବି ମୁଁ କହିଲି ଗୋଟେ ନେବେ ମୋବାଇଲ ଫୋନ ତାକୁ ଏନଲାର୍ଜ କରିବେ ତାକୁ ପଢିବେ
That has been taken off by the trial court, madam.
yes
The copy has been taken there.
yes
Therefore,
ମୁଁ ତ ଆଜି ସେଥିପାଇଁ ପଢୁଥିଲି but I can read it actually ଆପଣଙ୍କର ରନିଂ ହ୍ୟାଣ୍ଡରାଇଟିଂ ସେ ଜମା ପଢି ପାରିଲେନି କହିଲେ ଆପଣ ପଢନ୍ତୁ ମୁଁ କହିଲି ଆପଣ ଗୋଟେ ମୋବାଇଲ ଫୋନ
he permitted to withdraw.
Yes.
Trial court has been taken.
yes the memo state এটা সি দেবে এটা ରଖନ୍ତୁ ଆଜ୍ଞା which states thus memo shall be taken on record copy
In this
scanned copy be updated the petition stands disposed of the petition is disposed of accordingly what is para subpara accordingly yes
Item 13.
May submit.
Prasad Mohanty for the petition yes
Lord, in this case, my lord, on the last occasion on 29/4/2026,
yeah
your lordship directed the state council to take instruction with regard to my pending statutory objection under section 8 of the OPD. I am
No instruction has come, my lord.
Paragraph 3, my lord, last order.
yes I have seen that
My lord,
as you said I was looking at that
my lord.
ঠিক আছে better Prabhu should appear here when for Prabhu is appearing for the petitioner Prabhu should be there for the opposite party
My lord.
okay So Prabhu Prasad Mahanti for the petitioner.
Behera, my lord.
Prabhu Prasad, ଆପଣ କେମିତି ବେହେରା ହେବେ? ଆପଣ
ନାଇଁ ନାଇଁ
କୁହନ୍ତୁ।
versus my
Mr. Prabhu Prasanna Behera, Additional Standing Counsel, along with Mr. Prem Kumar Mahanti, Additional Standing Counsel for the state. The learned counsel for the petitioner refers to the order dated 29/4/2026, paragraph 3. It should not be kept pending, Mr. Mahanti or Mr. Prabhu, because if the section 8 has been filed, then that should be taken care of. But anyway, no, let them provide instruction. You don't take the responsibility. It is their baby, they have to take care of the baby. So gradually, you will learn it in the hard way. At times, you end up doing a thankless job when they don't take the responsibility. Particularly paragraph 3, and submits that state was to obtain instruction in view of the pending statutory objection under section 8 of the OPTR Act, which has been filed for consideration. It is submitted by the learned Additional Standing Counsel that no instruction has been received and the matter and further time may be granted. After vacation, Mr. Mahanti?
Yes.
Accordingly, the matter shall be listed for fresh admission in the week commencing. The week commencing on 3/6/2026. The State Council shall obtain instruction by the said date, so that the matter will be disposed of in view of the observations made in the order dated on 3/4/2026. Yes. In the interim, the interim order regarding adjournment of the matter before the authority is reiterated. Upon a prayer being made before the authority in season of the OPDR proceeding, the same shall be the proceeding shall be adjourned beyond 6/7/2026 to a date as would be convenient to the authority. Yes.
Item 14.
Yes, please.
My lord, item 14.
Yes, please.
I need some more time, my lord. Some
Yes,
research is required, my lord. May kindly be taken up.
Mr. Khirot Kumar Raut for the petitioner, opposite party blank. The learned counsel for the petitioner refers to the order dated 7/5/2026, wherein the facts as well as the legal issues have been noted after hearing the learned counsel. He submits that further time may be granted to enable him to obtain instruction. So accordingly, the matter shall be listed for fresh admission in the week commencing after vacation. 13/7/2026. Yes.
15.
May I please, Your Lord?
Yes.
I am on VC, my lord.
Yes, Mr. Pratap Chandra Misra for the petitioner. The learned counsel for the
I'm on
petitioner being present in the VC addresses arguments. Yes, please.
The improved order challenge before the Hon'Ble Court is at running page 49, my lord. Last page.
Yes.
49 of the brief. Where the learned judge, Hon'Ble Court Fulbani allowed the petition filed by the opposite party respondent wife, opposite party, who is the petition number 1 in the joint petition for divorce. That was filed under section 13B of Hindu Marriage Act. Where she filed a petition for withdrawal of the joint petition, herself from the joint petition, and that was allowed. That is the improved order challenge before the
provision that 13B.
13B, both the parties filed a 13B petition before the learned judge Hon'Ble Court Fulbani,
And after they also filed a waiving petition for cooling off the 6 months waiving period. That was also allowed. When the petition who is the petition here, he also filed his evidence affidavit. But the opposite party, wife, she did not file her evidence affidavit, but she filed a petition for withdrawal of the petition. That is the improved order challenge reposition report. That is the order dated 5/2/2026 at running page 49.
Sir, if it is a 13B on your own showing, what about you? Whether Mr. Mishra give an honest answer, whether you can withdraw 13 consent or not?
No.
No. File that affidavit.
After taking all the jewelry items and permanent alimony, she again withdrew herself from the joint petition. That is the subject of this. That is the subject matter, and that is the improved order challenge.
We are discussing law. You are addressing me on law. I am listening to you on law. Whether after receiving all jewelry and accepting permanent alimony, whether 13B can be withdrawn. So that is not the law. That has not evolved like that. You might have been cheated.
No, nothing.
Or that could be a ground for 13(1), cruelty and desertion.
She had earlier occasion, she had filed under a petition under section 10 of the Marriage Act for judicial separation. That was rejected. Thereafter, she filed a CRP petition. That was also withdrawn.
How many cases the wife has filed for dissolution, judicial separation, 13(1)? That is not important. That is not the subject matter we are discussing. We are on a plain and simple whether 13B after file can be withdrawn or not.
That cannot be withdrawn as per the
which provision, sir? Which provision? That must be a provision or some case law.
Case law. Case law. I will submit.
Guess it. Our problem is that when you are addressing or discussing these things, we are trying to second guess it. Law, this cannot be second guessed.
I will cite this one, and I will satisfy your lordship in.
ଆପଣ ସିନା ନିଜେ ସାଟିସ୍ଫାଏଡ୍ ହେଇ କେସଟା ଫାଇଲ କରିଥାନ୍ତେ, ଆପଣ ଏତେ ଡିସାଟିସ୍ଫାଏଡ୍
ଡିସିସନଟା ଅଛି
ପୁରା ଡିସାଟିସ୍ଫାଏଡ୍ ହେଇ କେସଟା ଫାଇଲ କଲେ।
No, there is a recent judgment.
ଆପଣ ଚାଲିଗଲେଣି ଯେ ସେ ପର୍ମାନେଣ୍ଟ ଆଲିମୋନି ଜୁଏଲାରୀ ନେଇଗଲେ ସେଥିପାଇଁ ସେଥିରେ 13B ରେ କଣ
there is a recent judgment of Hon'Ble.
Possibly ସେ ନେଇ ଯାଇଥିବେ, you have been cheated.
There is a recent judgment.
Recent कोउ जजमेंट हैला कोउठी हैला इंडिया रे हवा तो सुप्रीम कोर्ट रे हवा दरकार।
हां सुप्रीम कोर्ट 2026
हाई कोर्ट रे हवा दरकार।
ना सुप्रीम कोर्ट रे डिसीजन अछि कि one party cannot withdraw herself or himself.
सेटा तो आपण सैटिस्फाइड है कि फाइल करथाने सीधा लिखिथाने एटे डिसैटिस्फाइड है कि फाइल करले बर्तमान देयर इज अ स्ट्रगल फॉर मी एंड यू बोथ ऑफ अस। आपण आगो ग्राउंड नै चदी जे 13B फाइल हेले विथड्रॉ हबनी सेटा कोठी नाही। द्वितीय हला जे परमानेंट एलिमनी नै गले आसु नांती सेटा भी नाही। ज्वेलरी नै जाइछन्ती आ नाही। आपण कोर्ट रे डिपॉजिट करथांते। डज इट अपील टू कॉमन सेंस जे आपण एते भलो हेई गले ताकू देई देले आगुआ टंका। आपण 5000 टका पुओ को दिया होची ताकू आर्ग्यू करछन्ती लोक। 15000 टका छड़ सीमेंट टाइल बिकुचन्ती 15000 टका पे चाहे आर्गुमेंट चलची 45 मिनिट चलला 45 मिनिट घंटे।
Kindly have a glance.
मैटर सरतानी दीटा ऑडिटर तीनटा
my humble request, kindly have a glance running page 27, my lord. 27 of the brief. Where both of them are filed.
Let us not run around the pages. 27 or 72 make a legal submission जोटा कि सस्टेन करी हो। आपण कहउछन तो ओडे आ भीतर थरे फाइल ले होई परिबनी कॉन्सेप्ट सेही जिंसडा ओडे नहीं व्हाट यू आर सेइंग नो मिस्टर मिश्रा Mr. Mishra, in principle, I'm fully, I'm with you. This should not happen. But let us discuss law on this so that we can do something.
If the lordship will issue notice to the opposite party, and if she will answer why she withdrew herself from the 13B petition, That
Notice
can be
kale
answered
kichhi habani.
better.
You will end up in soup. Once she has withdrawn her consent and that's a part of the record of the court, how can you say that she has not withdrawn the consent? What is the point in 13B? How many cases? The law has not evolved. 13B usually challenge that after grant of decree of divorce, the conditions are not satisfied. But here, before grant of 13B, it has been withdrawn.
It has been withdrawn on the basis that there was a permanent alimony of 5 lakh and the petitioner had given 50,000, therefore she withdrew. Means on the false ground she has withdrawn. That is the main point of this case.
সেটা কাহিনী
On false
ଆପଣ
ground.
ତ ଆପଣ 5 ଲକ୍ଷ ଟଙ୍କା କୋର୍ଟରେ ଡିପୋଜିଟ୍ କରୁନାହାନ୍ତି ସେ 4 ଲକ୍ଷ 50 ନେବେ
50,000 ହେଇଥିଲା. There is no question of 5 lakh. There is only question of
ଆପଣ
50,000.
13B ରେ କୋଉଠି ଆଲିମୋନି କଥା ଲେଖା ହେଇଛି ଦେଖିବା 13B
ଅଛି ଆଜ୍ଞା 28 page. My lord 28 page.
28
page 28 joint petition 28.
ଆପଣ ଗୋଟେ ମୋବାଇଲ ଫୋନରେ ଆପଣ କୋଉଥିରେ ଲ୍ୟାପଟପ ରେ ନା ମୋବାଇଲ ଫୋନରେ କରୁଛନ୍ତି?
ନା ମୋବାଇଲ
ମୋବାଇଲ ଫୋନ ଜଣା ପଡୁଛି ଆପଣ ଗୋଟେ ଲ୍ୟାପଟପ ୟୁଜ କରନ୍ତୁ।
ଆଜ୍ଞା ସବୁ ଲାଗି 28
ମୁଁ କଣ ଆପଣ ଦେଇପାରିବି ଲ୍ୟାପଟପ ଆପଣ ନିଜେ କିଣିବେ ନା ଆଉ
ଆଜ୍ଞା 28 my lord page 28 can have a glance point C
ଆପଣ ପିଟିସନ ଟା ଦେଖୁଛନ୍ତି ଆପଣ 13B ଆପ୍ଲିକେସନ ଟା ଏଇଟା କଣ?
13B
ଠିକ ଅଛି yes got it.
Annexure 3 24 start ହେଇଛି 24 page ରୁ that is 28 page. The petition number 2 already paid a sum of rupees 50,000 to the petition number 2 towards permanent alimony as decided by both the sides.
50,000 permanent alimony ରେ ହବ ଆଜ୍ଞା?
ନା ତାର ଅଲଗା ଜିନିଷ ବି ସେ ନେଇଯାଇଛି ନା ତାର all the jewelry items.
ସେଇଟା ସେ ଆଗ୍ରି କରୁନାହାନ୍ତି she will withdraw.
She was ready.
You cannot.
She is a working lady. She is earning. My lord.
So it is because of your partly of your greed also. ଆପଣ 50,000 ଟଙ୍କାରେ ତାକୁ ରାଜି କରେଇଲେ ପ୍ରଥମେ ତାପରେ କହିଲେ ସେ ରାଜି ହେବାକୁ ବାଧ୍ୟ।
ନା ଆମେ ରାଜି କରେଇନୁ।
I thought but as I was listening to you I was thinking that out of 5 lakhs she has received 50,000 then the rest amount has not been set I mean fructified for her to receive.
ନା 5 lakh rupees question ଉଠି ନାହିଁ 50,000 ଟଙ୍କା ମୂଳରୁ ହିଁ ଥିଲା ପ୍ରଥମରୁ from the day one it was 50,000.
ଶୁଣନ୍ତୁ 13B withdrawal ଆଗ ଇଣ୍ଟରଫେରେନ୍ସ ଏକ୍ସାମିନ କରନ୍ତୁ ନିଜେ ସାଟିସ୍ଫାଇଡ୍ ହୁଅନ୍ତୁ ଆପଣ ଏତେ ଡିସାଟିସ୍ଫାଇଡ୍ ହେଇକି ସବମିଶନ କଲେ ହବନି. You satisfy yourself. 13B withdrawal also can be challenged because it's a pure question of fact. It can't be a question of mixed question also. 13B grant hela pore there are certain provisions jothre challenge kari hobo like this amount permanent alimony withdrawal of cases withdraw karunahanti many times you will find after the decree is granted the cases are yet pending.
Judgment.
Mr. Pratap Chandra Misra for the petitioner opposite party blank. The petitioner is the husband in the marriage and he continues to do so despite his efforts. The petitioner is before this court challenging the order passed by the
judge family court Fulban.
ଆପଣ ଏତେ କେସ୍ ହେଇଯାଇଛି ତାକୁ ପାଇବା କଷ୍ଟ ହେଇଗଲା. The order passed by the judge family court Fulbani dated 18/7/2025 in CP number 26 of 2025. The CP number 26 of 2025 was filed by the petitioner husband in the marriage and the wife in the marriage. By a joint application under section 13 into bracket capital B of the Hindu Marriage Act, seeking decree of divorce by mutual consent. Thereafter, for exemption of the statutory period of 1 year, the application was filed. Statutory period as prescribed under section 13 capital B into bracket small English 2 of the Hindu Marriage Act was filed, citing the decision of the Honorable Apex Court in Amardeep Singh versus Harbin Kaur, 2017, 88 SCC 748. The said application was allowed by order dated 9/10/2025. ଆପଣ 9/10 ପରେ ଯୋଉ ପକେଇକି ରଖିଲେ that was a mistake. You should have immediately acted upon that. Thereafter, petition under order 23, rule 1, read with section 151 of the CPC was filed of CPC was filed by the wife withdrawing the petition on her behalf under section 13B. Stop. The prayer of the opposite party wife to withdraw her petition under section 13 capital B was allowed by order dated 5/2/2026. On being apprised how the withdrawal by the wife can be challenged by the husband, in case of a 13B application, the learned counsel for the petitioner seeks and has adjournment, stating that he will rely upon certain case law. Stop. Accordingly, the matter is adjourned to be listed for fresh admission in the week commencing 29. The week commencing 29, Mr. Mishra, na kebe? Na July re?
Ensuing up summer vacation pare.
July re na June re? June 29 hoji first week after vacation.
First week after na 29 July, 29 June.
29 June re ta?
29 June pare jo saptah.
Pare kouchandi. Acha. 13 in the week commencing 13/7. Yes. ଆପଣ ତା ଭିତରେ ତାଙ୍କୁ ରାଜି କରେଇକି ଆଉ ଥରେ 13B କରିଦିଅନ୍ତୁ। ଆଉ ଗୋଟେ order 23 rule 1 ଫାଇଲ କରିକି ସେଟାକୁ ଆଉ ଥରେ withdraw କରିଦିଅନ୍ତୁ।
Lordship would have sent notice so that matter could have been.
Again, notice you must understand. You must understand that 13B I don't have. Usually I am sitting single. I was sitting on that side when taking up MATA. 13B order, how can I do? I cannot do, in fact. I don't know whether I can have this writ petition also. Section 13B, the appellate authority is a division bench. Appellate court is not the single bench. But ଆପଣଙ୍କର ସେଗୁଡାକ କିଏ ଆମେ ତ କିଛି ପଢାପଢି କରିବାନି. So if this question is asked, then what is your answer? How the writ petition is maintainable? Yes. The answer perhaps would be order 23 rule 1 is interlocutory application. So these are legal niceties. Yes, next.
Item 16.
16, Mr. Subir Palit, senior advocate, along with Ms. A. Pradhan, for the petitioner. The matter being listed for fresh admission is mentioned by the Lord Senior Counsel at the beginning of the day's proceeding to be taken up. Stop. ये ऑर्डर टा पास कर दे पूरा नोटिस जीरो ना कितना नंबर आइटम है 60 हां लिखा है डेटा डेट के पे क्वेश्चन है अपन डेट तो बोले मु तो लिखिना अपन क्वेश्चन 13/7 वो कम से 13/7 तो कनेक्टेड मैटर कोन 13/7 रे आछ ठीक है
17.
paucity of time intervenes. The matter shall be listed for fresh admission in the week commencing 13/7/2026 for fresh admission. Yes, next. Smruti Pragya. The Nada कौन कहले? Smruti Pragya. Pradhan. On behalf of Deepak Kumar Mahapatra for the petitioner. The learned counsel for the petitioner submits that the defect as pointed by the registry by the SR has been removed. She further submits that the efforts of the learned counsel for the petitioner to contact the petitioner does not yield any result. The petitioner remains incommunicado. She seeks further time to obtain instruction. So, registry shall verify, and if defects have been removed as stated, the matter shall be listed for fresh admission in the week commencing 13/7/2026. Yes, next.
Item 20.
Posting कर दिया तो orders में. The Mr. was, I think, someone was present. ठीक है, कर दिया for orders. 20 paucity of time intervenes. The list for orders in the week commencing
on 3/6.
Item 21.
Item 21, my lord, pray for time for production of certified copy.
अरे 22 मसीह 4 वर्ष हो गला आगे सर्टिफाइड कॉपी.
My lord, I am contacted with the petitioner.
I grant further time beyond 4 years also. ठीक अछि. Mr. Atmojit, you should ask your soul also these questions. These are soul-stirring questions. You being Atmojit, you must ask this question. 4 वर्ष ପରେ prayer କରିବା, court grant କରିବା, certified copy आउथरे आसीबो. The learned counsel for the petitioner raises a soul-stirring issue. Mr. Atmojit Manmohan Das for the petitioner. The office note indicates that certified copy has not yet been filed and stamp reporting could not be made. The matter was earlier listed. On 4/5/2026 and the following order was passed. The efforts of the registry to reach out to the learned counsel for the petitioner has yielded result. The learned counsel for the petitioner appears, but again, prays for time. Stop. कितने दिन में देवे सर?
मतलब 2 weeks भीतर दे दी.
The learned counsel for the prays for time to file certified copy, to obtain certified copy of the impugned order and file the same. Accordingly, it is directed the certified copy shall be filed within 15 working days peremptorily. Failure to do so shall entail rejection of the petition. Stop. The matter shall be listed for orders in the week commencing 27/2024. Yes, next.
Item 23.
Yes, Mr. Mahanti.
After petition, I will take instruction regarding.
Okay, Mr. Vikram Kesari Mohanty for the petitioner. Opposite party blank. The learned counsel for the petitioner refers to the earlier order dated 23/2/2026 and the subsequent order dated 16/3/2026. He seeks further adjournment to obtain instruction. Stop. Accordingly, the matter shall be listed for orders in the week commencing 13/7/2026. Accordingly, to grant further opportunity to the petitioner, the matter shall be listed further. Yes, next.
Item 24.
Paucity of time intervenes. The matter shall be listed for orders in the week commencing 29/6/2026. Yes, please. Next.
25. Application to take instruction as regard to the payment of the amount fixed by the
25. Mr. Manoranjan Muduli for the petitioner. Referring to the order dated 30/4/2026, the learned counsel for the petitioner seeks adjournment to obtain instructions. Okay. Particularly with reference to paragraph 11. To grant further opportunity to the petitioner, the matter shall be listed for orders in the week commencing 20/7/2026.
Sir.
Aguru.
ठीक है जॉब लाइज में
20/7
Oblige.
6/7 102टा से रख सारे ସେଥିପାଇଁ 20/7 କରୁଛୁ 13/7 ହେଇପାରିବ 13/7 ଯଦି 13/7 13/94 94 ମାନେ today it has crossed 100. Yes.
26.
Paucity of time intervenes, the matter shall be listed for orders in the week commencing 20/7/2026.
27.
The Santon Ponda for the petitioner. कौन करिया तो नोटिस गला से कोठी अपियर करछंती की
Leadership already the family court Noyagad there she is appearing.
सेठी नेउना सेठी त नहीं थाते ना तोरा प्रथम दिन कहवार थिला आपण दियंतु डिटेल्स दियंतु वो केस कोन को दिन अछि कि जानचंती
मिलन
कोन नांती the office note indicates that लिखिले that appearance देखिछि हां तो Santon Ponda for the petitioner. The office note indicates that speed post notice issued to the sole OP has been returned unserved with the report addressee left without instruction. Stop. It is submitted by the learned counsel for the petitioner that the opposite party is appearing before the learned judge family court in
Noyagad.
देखिए दियंतु in Noyagad in CP number
in CP in CMP number.
In CMP number
in CMP number.
CMP number एते
in CM number 36/2020
family court.
Family court.
He seeks leave to take notice to the said learned court. Accordingly, petitioner shall have liberty to take notice afresh, for which requisites shall be filed to be communicated to the office of the learned judge family court Noyagad. Stop. It shall be ensured that the notice issued by this court is served on the opposite party in person as well as the learned counsel appearing on her behalf in CMP number 8. Tombata koi. Requisites filed ke din 5 din mein debe na 3 din.
5 din.
Requisites for issuance of notice to the court shall be filed within 5 working days. Unutilized copies returned answered shall be utilized. Returnable date be fixed afresh to fixed to 6/7. The matter shall be listed for orders in the week commencing 13/7. Yes.
Sorry.
24 simply adjourned each. Because after 4:15 I have not marked anyone absent. কোন ডেট কই পারিবে টি মিস্টার বারি
29/6
29/6
ভুল ক্রমে 29
yes
28
Taking in your lordship's observation, yeah, I have filed application to implement IDCO as a party because project proponent has not even decided.
IDCO was the requisitioning authority ଆପଣ କହୁଛନ୍ତି IDCO ନେଇକି ଆପଣଙ୍କୁ ଦେଲେ
IDCO has taken the
IDCO has taken the land. So actually that is legally sound also because that judgment, other judgment which says that subsequent annuity may not be made party, but initial requisitioning is the IDCO.
It is for ultra
You
mega
take
power
notice to
project.
IDCO.
IDCO, I have already.
आइए मिस्टर शांति प्रकाश महांती फॉर द पिटिशनर এটা 28 नंबर है LAA 38 of 2026 along with IA 109 of 2026.
I have also filed corrected consolidated cost item.
Okay. IA has been filed delay notice issue हैनी IA लिखुंतु आगे अलगा लिखुंतु ने LAA लिखुंतु IA 109 of 2026 the IA has been filed under chapter 6 rule 27 of the Odisha High Court rules for seeking leave to for appeal. ଆପଣ ପାର୍ଟି ନଥିଲେ?
I am not the party. We are not the parties.
Not the party. Seeking leave to appeal as the present appellants were not parties before the referral court in LA reference case number 70 of 2016. Decided by senior civil judge Sundargarh. Na civil judge senior division Sundargarh. Senior civil judge Sundargarh arising out of LA case number 16 of 2010 before the special LAO ultra mega power project Sundargarh. Stop. It is submitted that how you are saying that you are affected necessary party?
Because my mother, our mother was the co-sharer.
Okay. It is submitted that the present appellants are descendants of their mother, Srimati Dhanamati. Srimati Dhanamati, who is the co-sharer of the property that was acquired, she being Srimati Dhanamati being 50% of the compensation amount. You have named her to be Dhanamati or she is actually Dhanamati, Mr. Mahanti?
Pardon?
Because you are seeking Dhana through her, you have named her to be Dhanamati or nothing like that. But she has proved to be Dhanamati for you.
Actually, the present respondent number 2 and 3, father of the
daughter's right for inheritance ଆପଣ claim କରୁଛନ୍ତି ବୋଧେ?
50% of the
correct. Issue notice ଏଥିରେ respondents party ହେଇଛନ୍ତି
2 and 3. They are the
issue notice to the opposite parties as respondents. Sri Prabhu Prasanna Behera, learned additional. ଆପଣଙ୍କର ତ?
My lords.
So Prabhu Prasanna Behera, learned additional standing counsel upon advance copy served appears and waives notice on behalf of the OP number 1. Issue notice to the OP number 2.
Respondent number 2 and
OP2 dash R2, OP3 R3, OP4 R4. R4 newly added over. Can RO is added by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 7 within 5 छुट्टी पूर्व रहले 5 working days दरकार ठीक अछि within 5 working days returnable date be fixed to करंतु
13/7
returnable date be fixed to 13/7/2024 the matter shall be listed in the week commencing 20/7 20/7/2026 ତା ପୂର୍ବରୁ ଲେଖିବେ ଆ ପୂର୍ବରୁ ଲେଖିବେ ଯୋଉ ଆରଟା ଆର ଆଇଟା 168 ବୋଧେ 168 of 2026 IA 168 of 2026 the application has been filed in the appeal along with the appeal under order 6 rule 17 of the CPC seeking improvement of the requisitioning authority for which the land was acquired.
In the land also stand in the name of
Submitted that,
IDCO. I have
submitted that the land stands recorded name of Industrial Development Corporation of Odisha Limited, a statutory corporation.
That also I have annexed. Annex of 13.
Who is the requisitioning authority and in whose name the land stands recorded? In view of the judgment of the Honorable Supreme Court in UP Awas Ebang Vikas Nigam, so and so petition Constitution Bench, observing that in matters of land acquisition, seeking enhancement of compensation, apportionment of compensation, the project proponent oblique requisitioning authority should be made a party. The prayer made in the IA has to be allowed. Accordingly, the prayer for implementing OII Odisha Industrial Infrastructure Development Corporation into bracket IDCO is allowed. The IA is favored and disposed of. It is submitted by the Learned Counsel for the petitioner that about a consolidated file korchoti. Consolidated cost item including IDCO as OP with the R4 oblique OP4 has already been filed, which is on record. Copy of the amended cost title has been served.
No, I may request for.
Copy of the amended cost title shall be served on the Learned Counsel for the state within 2 working days. Stop. The amended cost title shall be taken on record, scanned copy be updated. इटा हला परे आपण ताते नोटिस इशू करछथि आपण समस्त 3 जण को नोटिस नेबे इडको भी नोटिस होछथि जोटा लीव टू अपील रे यस सेम ऑफ दैट आपण को लिस्टिंग डेट डिटरमिनेबल डेट सेंड कर इते 13/7/2027 यस
Item 30.
Lordship, I may be pardoned. Item number 23, my appearance may be noted, my lord.
23
My lord, 30 रा କହିଥିଲା
23 Mr. Vikram Mohanty ko gode thila.
Yes, my lord. My senior was appearing for petitioner. I am for the opposite party, my lord.
A Das for the he sought for adjournment.
Then all right.
Yes. Yes.
Item 30.
I am the opposite party, my lord. ସେମାନେ ଆସୁନାହାନ୍ତି ନା କିଛି କରୁନାହାନ୍ତି ଆମର ପାର୍ଟ ଆଡେ ହେଇକି ଅଛି
Last order कोण ହେଇଥିଲା मैडम दଳ
ପାର୍ଟ ଆଡେ ହେଇକି ଥିଲା ଆମର ହିୟରିଂ ହଉଥିଲା ପାର୍ଟ ଆଡେ ହେଇକି ଥିଲା ସେମାନେ କରିଥିଲେ ଆଉ ଆସିଲେନି ସେମାନେ ଆର୍ଜନ ଉପରେ ଆର୍ଜନ କରୁଛନ୍ତି
नॉन अपेरेंस करी होबनी काना 4:15 पर यूजुअली मु करेनी एबे 4:30 भी हेगला तो इट इज मच बियॉन्ड द टाइम देखिबा देखिए the petitioner blank opposite party Dipti Dhar. Hela. Paucity of time intervenes. The matter is mentioned by the learned counsel for the respondent. She submits that after hearing of the matter on 10/3/2026, there has been several adjournments, or it could not reach during course of the day when it was listed. The adjournment the adjournment recorded like the matter could not reach when it is listed during the course of the day or during day's proceeding. She reiterates her submission that the opposite party wife and the child, one from the wedlock, who is now a young adult, are deprived of the maintenance granted by the learned judge family court, so on. Family court dash Roman 2, Bhubaneswar. She submits that the matter may be listed for orders. So, accordingly, the matter shall be listed for orders in the week commencing 6/7/2024. Yes, next.
23.
नहीं मो 23 पड़ेला आपण भूल गए 33 को 32 को आपण डॉक्यूमेंट 23 कौन पड़ेला लेकिन डिस्चार्ज हे गला ओके क्रॉस कनेक्शन हे गला
33
पोस्टिंग कर दियो हैला एनीवन सीकिंग एनी पर्टिकुलर मैटर मेंशन करछथि
तुम नंबर 45
Interim model may be considered. Let us go serially. The way we are going serially, Jantu.
Yes,
33, 34,
35, 35, 37.
37. Mr. Mahanti was present. And put date kar diyantu.
We count in 47.
47 Mr. Mahanti. It's 38.
39.
39, my lord, I am there.
39 8 कर दियो तो
We count in 27.
27 है Miss Das, Mrs. Das.
Yeah.
40 टा मेंशन करिथिले सा पर नेक्स्ट पेज को जातो. Yes.
41. 42.
42.
About 42 may be listed on supplementary this week. Kindly, if you can. Very important.
Kim kya not possible.
Wife is on
The
very
problem, madam, is that
condition.
the problem is that the nature of cases we have to deal with. It takes time. It has to take time because hearing what is suggested date केबे कोहंतु आसीबो
Friday.
छुट्टी पूर्व रखंतु नि आपनकर निजर प्रोग्राम अछि बुधवार प्रोग्राम ऐसे अछि सो then we are also going trying to save energy by going busy.
Then on the opening week of
Opening week रे देखंतु से 29 6 रे रखंतु.
We count in 29.
Yes. 43, 44, 45.
45 madam.
Yes,
I am
Mr.
for
Sahu.
petitioner madam.
Date चाहूँगी.
Kindly fix the date.
45 date करो जाइए.
45.
We count in 47.
47 week.
No interim order is there madam.
कौन adjournment order? ना stay order.
Update sir.
तो अच्छी आपनकर stay अछि 5/12/25 till next date of hearing.
Yes ma'am.
So it's not disturbed.
Yes ma'am.
The order remains untouched.
Yes,
Date gote hela.
Yes.
उत्तर करिवे. 46, 47?
47 there. My lord, I am there.
47 date କରନ୍ତୁ.
वो करेक्शन 27/7.
Commenting 27/7.
My lord, yes.
Simply adjournment. ଆପଣଙ୍କର posting ହେଇଯାଉଛି computer. Order କିଛି ପାର.
Due to stay order of proceeding is stayed since December stay ରହିଛି.
The difficulty is that it has to reach and to be heard. Once a coordinate bench has passed a order, I cannot just simply throw it and simply jump into the. You have to be patient there.
The Tamil Court of Orissa not.
So that is one of the approach that I am trying to hear it at the initial first instance itself. That is one of the reasons. What you are saying is a matter of concern. That is,
The last 6 months it is still.
48, 49, 48 years. What do you want?
48, my lords, in one similar parties involved in same CRLMC, same parties, there was a mediation. Matter was referred to mediation. Mediation has been concluded, and can it be the CRLMC has been posted to 21st May? Can it be on 21st or 22nd? Because they have agreed that the matter may be transferred to Jaipur on the prayer of the wife.
What 21 ଚାହୁଁଛନ୍ତି ଆସିବ ବୋଲି?
My lords. Other side is also not there. That is why I am saying in presence of both the.
ଆପଣ ଯଦି ଗୋଟେ ମେମୋ ଦେବେ ତାହେଲେ ସେଦିନ ହବ ତାହେଲେ ଦେଖନ୍ତୁ ଏଇଟା ଆଣିଥାନ୍ତୁ 21
ତାରିଖ order ଟା ବି ଅଛି your lordship.
But you have to take your chance. ସେଦିନ ଆପଣଙ୍କର it all depends on both the learned counsel.
My lords.
On that day, if you even that memo would have what if would have filed today if they are agreeing for transfer to Jaipur.
My lords.
So this can be disposed of. But today that is not there. On 21 को आनिଥାନ୍ତୁ
21 को
ସେଦିନ mention କରିବେ?
ସେଦିନ mention କରିବେ, my lords.
But both of you.
My lords, the other side I'll inform.
Yes.
Much obliged.
4950, 5152.
Lordship, item number 51.
Yes, what do you want?
Lordship, I am on behalf of opposite party wife. In this case, divorce proceeding has been stayed in the lower court. Lordship, kindly can it be posted to tomorrow?
WPC रे divorce केमती stay ହେବ sir?
Sure, family court interim order has been, IA has been filed.
IA कौन ପାଇଁ?
In paragraph 7 of the last order, as an interim measure, it is directed that a land judge family court Bhubaneswar shall adjourn the CP this to 27/4/2026. Lordship, can it in this case be posted to tomorrow or day after tomorrow?
କେବେ କରିପାରିବେ? ଆଜ୍ଞା, day after tomorrow. ଦେଖନ୍ତୁ, take your chance. Yes.
My pardon.
26 matter actually computer ଉପରକୁ ଯାଇପାରିବନି. After this computer is listing us for the last 10-15 years, numerically the priority goes. That is one of the reasons also. So if both sides are present, then it's a different thing. ठीक है, list ଥାଉ ଦେଖିବା. 52 sir.
Item 52. My lords can be taken after vacation.
52 date କରନ୍ତୁ.
Date करते.
वो कौन से 20 से?
27
Pardon to mention, my lord, item 17 lords non-appearance is
17.
Item 17.
53 Mr. Kashyap, Central Government Council के थे. So after vacation होगा. What do you?
Item 39, my lord. My presence can be noted. Item 39, I am for the opposite party. Item
39 reach करीन.
Adjourn to.
So no, I mean, no non-appearance is never marked.
Yes,
After 4-15 ପରେ କିଛି mark ହେଇନି.
Yes.
17 को तो ଆପଣଙ୍କ ଆଗୁଆ କଲ୍ ହେଇଥିଲା. ତ 17 ରେ କଣ ହେଇଥିଲା ଡେଟ୍ ହେଇଛି?
ନା पर जो कौन से 13/7.
ଏ appearance ଟା mark କରିଦେବେ. Your name is
Kamalakant Sethi.
Mr. Sethi.
Lords.
Karunakar Sethi.
Kamalakant Sethi.
Mr. KK Sethi on behalf of 17 ଟା ଲେଖିବେ ସତ୍ୟଜିତ. 17 ଲେଖିବେ. Kamalakant Sethi on behalf of Sethijit. 6 for adjournment କରିଦେବେ. Non-assurance नौकरी कर 6 for adjournment. The matter shall be listed.
वो कौन से 13
matter shall be listed for orders.
orders.
For orders, we commencing 13/7/2024.
Much love.
Yes.